Good morning. Good morning. Good morning. It's Thursday. It's April 6th. It's time for Coffee and Kersey. Today we are endeavoring poorly to catch up on the cases that have still been moving while I have been covering trials because a lot has happened in the law since, really since the beginning of the Murdaugh case, which feels like months ago now because I have been doing trial coverage for just about 8 weeks. So a lot has happened. Today we are catching up with Cousin Eddie's bail hearing or his bond reconsideration hearing. Do I feel deeply one way or the other about Cousin Eddie's bond? No. Do I miss Judge Newman? Yes. And since Judge Newman is presiding over all of these cases, we're going to just revisit him for a little bit and then also see what's happening with Cousin Eddie and kind of fill in the gaps on that case. And then we're going to cover the Markle v. Markle dismissal. I know that this has been covered elsewhere. This happened right at the end of the Paltrow case, but today is our time to get into it. There are other cases that I am looking at for next week. You're going to ask me about them. I'm going to tell you now I'm looking in for them for next week. Here's why. First, there is a young lady and a goat, and we are going to be looking into it, but I have not had time to read the search warrant. Are you, chat, are you following this? Are you following this in California with the woman, the 9-year-old and her goat? It was like a 4-H situation, but there's a warrant that I haven't had a chance to read. And so it's not as easy as just a, hey, there's a girl and a goat. I know that Runkle covered it. So I want to read the search warrant and go through it. There are a lot of quirks of law, like can 9-year-olds own property and all of it. But there is so much going on in that case. So I will be covering the goat case next week. I really didn't want to read the search warrant on stream because it's pretty long. And I wanted to make sure to go through it. And it needs some thought. My husband's an FFA guy. So it needs a little more processing from me that I just didn't have bandwidth for this week. Because once I started reading it, I was like, yes, I could give cursory coverage of it, but that's not what you're here for. You're here for my thoughts on it, and I need more time to give thoughts on it because you know how we feel about goats here. My car horn is a goat scream. Vincent Van Gogh is a friend. So we will have to get into all of it with the 9-year-old, the 4-H auction, and the goat. My husband's like, did she walk the goat across the auction block? I'm like, they do that? So I also am not a 4-H FFA person, but I am here to learn. I want to see about the search warrant. So that's what we're doing next week. Then there is the question about the judge who was fired for OnlyFans. As I started looking into that story, it is a deeper story than just judge has OnlyFans, OnlyFans gets discovered, and judge gets fired. So because I have not had time and opportunity to pull up all of the codes of responsibility in New York for this judge, I want to dive into that a little bit more deeply. But again, the things that I'm looking at are all like, oh, here's the surface level of this case. But then here's all this other context of this case. And with the judge, there really is a lot of other context. It's not just OnlyFans. There are politics involved. There is a judge exercising First Amendment rights, whether OnlyFans is a First Amendment right, whether you can actually tell some other government official mean things on Twitter and still keep your job. That judge that case has a lot more than just an OnlyFans was discovered and that was a problem. So because of that, I want to make sure to go more deeply. That sounds terrible when I'm talking, whatever. I want to look more into the context around that because it seems like there is maybe some political wrangling that then the OF became kind of the thing that was used to be weaponized against this judge because of political speech. So with all of that, it's not just as simple as, oh, a judge had an OnlyFans, and does that meet judicial ethics? There's so much more context to it. So those are on deck for next week. And I appreciate you understanding that when there's more context, I really want to try to understand the context instead of wading into something and being like, "Oh, this is a lot deeper than we thought it was." Because you could think it's surface level, but it's not. That that case just drives it home, I think, maybe. All the innuendos with that one, but we will get there. For those of you asking what FFA is, Future Farmers of America, and for those of you asking what OF is or OnlyFans, it is a site where adults can post adult specific and explicit content as they like. So the OnlyFans case is really more of a case of like political intrigue in the First Amendment and also OnlyFans. So, so we're going to have to get into it with more context. I was like, oh, this will be just a quick nope. Nope, it sure won't. Everything I looked at was a little bit more than that. So I think there's really valuable conversations to be had. I just need more time for the context because I haven't had time to to go down that rabbit hole all the way yet. So with that, today we are just keeping it to Cousin Eddie and the delightful Judge Newman and the Markle v. Markle case, because the Markle case is a really good time to exercise the two things can be true at once, because Meghan Markle is a very polarizing figure, but we're going to take a look at this defamation case and really be able to exercise, okay, how do I feel about this person, and put that to the side, whether it's like rooting for or rooting against, and then actually evaluating the case. It is a very valuable exercise and we learned a lot. So with all of that, I'm going to roll the intro and then we have one more thing. We have a few other housekeeping matters to get to. So let's roll the intro and go from there. So, Law Nerds, where are you coming in from? What are you drinking? Chat, it's good to see you. Let's roll.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
All right. Before we move all the way on, I'm trying to pull something up that I did not pull up fast enough. So if you give me 1 second, and I beg the chat's forgiveness, I wanted to share something that I have shared before and will be sharing more, but let me go to this, allow. All right. We're trying to pull things up and it's not always easy. We are going to talk about our friend Captain Kori for just a moment, because I wanted to give an update. B, I wanted to direct you towards Captain Kori's channel, because a lot of you have joined me during the last two trials, during either Murdaugh or Paltrow. If that's you, please feel free to pop a 1 in the chat. We love our new law nerds, but there are some things we need to catch up on. So with our law nerds, Captain Kori is a young YouTuber who is on palliative care in the UK. He had a Make-A-Wish wish granted and got to have a phone call from and a video sent from Johnny Depp dressed as Captain Jack Sparrow. So Captain Kori goes by Captain Kori, and his YouTube channel is Crack in the Box, which I think is just absolutely delightful. And he and his family have been sharing their journey with his heart failure, with his prior surgeries, with what hospice for children looks like, with what his adventure on YouTube has looked like. He is not doing well. And this is something his family has known, and they talk a lot about how they're engaging with that in their videos and what that is like for him, but also, you know, the outpouring of love and support, not just for Kori, but for his family. One of his dreams was to get a silver play button on YouTube, which he did 3 months ago. So over the Christmas holidays, there was a tremendous outpouring of support for his family. and a tremendous amount of love. So, with all of that, if you would still like to subscribe to his channel and still keep the love flowing in, I think his family can use it. What I really appreciate is seeing not just how much love, but the joy that something like YouTube can bring, and the joy that um, the joy that a community like YouTube can bring, and that is something that can't be understated. That as difficult as the journey for Kori's family is and has been and will continue to be, that they were able to find a lot of joy. And this is so hard to talk about. I'm sorry, chat. I can't control my voice because it just, the amount of joy that his family has shared on their channel during very difficult times is inspiring and is absolutely incredible. And seeing how much YouTube played a role in that is why YouTube is such a beautiful community, because it brings stories that we might never touch on, and it brings light and joy and community. And so, while it's been a difficult journey, I think his family has shared so much joy with difficult and unfathomable circumstances. And the joy is really what I want to share, because I think it's been incredible to see them normalize something that we don't like to talk about. And I can only imagine how isolating it would feel as a parent to not be able to talk about it because it's hard for other people. It's a hard story. It's heartbreaking. It's sad. But how isolating must that be to not be able to share your story? So the fact that the internet has been able to bring community and joy and celebration around something that can be difficult to talk about and difficult to address, but that is real, um, is so absolutely incredible to me. And I have the utmost just I don't know if respect is the right word. Awe, maybe? Respect doesn't feel like a big enough word. I have so much awe for how they've shared their journey and how it might help other families not feel so alone when they go through things that are difficult. For me, I am a mom of kids who were in the NICU. It's a very isolating experience, or can be, because other people are like, "Oh my god, that's so sad." And you're like, "Well, it is, but it's what I'm living through right now." And I think it's easier to share sometimes just the positive, but I think that Corey's story is tremendously positive, even though it's difficult, and they know that his journey is going to be a short one. And that is the power of community for me. So I'm sorry for all of you that are like, "Oh my goodness, this is so hard." It is. And I just have so much respect for the way they've shared their story, and so much respect for the way that there's been such an outpouring of love. This community and others across the internet got Corey's channel to 100K in a split. And it was just incredible to see the joy when he got his play button, when he got his leather play button from Runkle, when he got gifts from Ian and others. He has gotten so much love and support, but not just for him, for his siblings, for his family, for his mom. So if you want a little bit of a bright spot in your day, even amid something that can be difficult, um, this is incredible. So Corey's mom, let me go grab her Twitter, and I have not been on Twitter today. I know that he has not been doing well. Um, and so I know that that is where they are. I know that he is in hospice. So with that, and I see that she has an update from 2 hours ago. I have not watched that yet, but I wanted to share Kori's mom's Twitter. I know she also has her own YouTube. Let me can I just copy the link to profile? So if you would like to follow along on Pixie's Twitter, you can. And it's Pixie Crap Goth, CRAP. So if you want to go follow along on Pixie's Twitter, go follow along. I know that she had shared, she shares updates and she has shared links to where Kori is, where you can donate at rainbows.co.uk. There is a fundraiser coming up that is going to be on Popcorn Planet's channel for Make a Wish. So there are some other fundraising opportunities coming up, but they have also, with all of the outpouring of love and support from the internet, they have also raised a tremendous amount of support and gifts and donations in kind for the hospitals that they've worked with and for the places that have supported them. So they've really used the growth of their YouTube channel and people touching their story to also help other children who are in same or similar situations that don't have a presence on the internet. And it's been really incredible to see. So I know there is a Facebook page as well. And you can find all of that from Pixie's, oh my God, the blanket is so cute, from Pixie's Twitter and then from Pixie's own YouTube. So this is YouTube. Pixie, I'm gonna message Pixie and be like, put a link. We need a link. But that's where you can keep up with all of that. So I know that he's not been doing well. So hopefully a bump in some subscribers will bring a smile. I know that YouTube has been really important to their journey. So it's just been absolutely incredible to see this story. And if you are looking for a story to share or a story to engage with, there is so much good that can happen on the internet. And thank you for being the good that happens on the internet. But I had been watching all of the updates from his mom, and we've talked about it when he hit 100K and hadn't talked about it during trial coverage. And so I am happy to circle back and share with all of you that are just coming to this channel how much the internet can mean and how much joy it can bring even in difficult circumstances. And that is something I love about this community and something that I love about, I don't know, the light side of the internet. There's plenty of dark to be found, right? But there's also so much connection and community and humanity and support all across the world. And that's the thing I really like seeing. And I like seeing the joy. And I'm so touched by this, by just getting to kind of be a witness to this incredible journey with this family, and that they shared it with us and so many on the internet. So with all of that, thank you, all of you who go and subscribe, who engage with videos, who leave positive comments, and just send the family the love, support, and thoughts that they are going to need as they walk through what the coming days and weeks have to bring. So with all of that, thank you. Kori's channel is a lot of fun. I think the first video on the channel, there's a few quick videos, and then there's a message from Johnny Depp. And that's just, it's really fun to see. And then a phone call. It's a fun journey. And then seeing the mail calls and the gifts and the 100,000 milestone and the play button getting there from YouTube. It's a really fun journey to watch. So if you have not subscribed yet, do that. And then I know that Kori also wants to see if his mom can get to 100K, and his mom's channel is The Crap Goth. I will here. Let me see if we've got let me pull a link real quick to it. So give me 1 second and then our mods will have it too. So thank you all. For those of you that want to follow along, I appreciate you. So thank you, thank you, thank you. And thank you, Michelina, for adding that to the description. I appreciate you. I know a lot of you have been following this story since the holidays, so I wanted to touch back in because, again, touching in when things are good is really easy. Touching in when things are hard is different, but I think this community brings a lot of compassion and love and support to that, and I appreciate you, and I don't know how else to say that other than it really does touch my heart to see what a positive impact community makes, and I thank you for being a part of it. So, sorry for the swing into things that are a little more challenging, but it's just it matters so much and it makes such a big difference and is such an easy thing. So, all of that I will be sharing more over the weekend and in the coming weeks, but the thing now I'm repeating myself, the thing that I'm so inspired by is their open sharing so that others don't feel so alone walking through things that are difficult. I know how isolating health stuff can be, and I think it's incredible that they're not allowing that to be the case. And I think there's a lot of room for us to support each other, not just in our wins, but also in our challenges. And it takes a lot of courage to share those on the internet because the internet can be real rude. The internet can be real rude. Even to Kori, the internet can be real rude. Ashton Upton, you're gonna have to keep watching because it sure was. Are you guys ready? Are you guys ready to switch over? Carbonized Stardust. I see your comment in the chat. Yes. Yes. Share. We learn. I'm gonna just share this and then we're gonna move on and we're gonna talk about Cousin Eddie. Sharing what you're going through and sharing how you're doing it helps others. The only way I learned about some of the things that I have gone through and struggled with is through conversations with others. We are humans and we learn through talking to each other. It's why apps like Twitter can be so great, but then also be so not great, because us being able to talk to each other from all different experiences and all different walks of life is a really powerful thing for all of us to grow and to learn and to just human a bit better and a bit kinder to each other and to ourselves. But also, you never know if you're talking to a real person, if you're talking to not a real person, if somebody's on there and they just want to fight, and then you're not having a real human interaction because you wouldn't have that interaction in person. And so nuance can get lost on the internet and those conversations can be hard. But we find these little pockets of the internet when we can have nuanced conversations and we can come at it with compassion. I talked about this on Tuesday. I'm talking about it again today because it matters so much. And I think right now we can all use the reminder when it feels sometimes like you just want to scream into the void or yell at people on Twitter saying awful things, and that's not the best use of our energy. But it's really hard to have a conversation when people are very deep into their emotions and feel like they are being attacked if you question why they think something, question their position. And we're seeing more and more the conflict getting very loud and the listening getting very damped down under emotion and fear and anger and people feeling attacked, even when they're not being attacked because they're already defensive. And we're not really in a good position to make change and find compromise and find understanding when we're in that mindset. So all of it, we are walking through difficult times where people are scared, angry, hurt, and we're not supported in navigating that in a compassionate way at the moment. And that's why we do that here. We support it in a compassionate way and we talk about it so that we can all process through it. And it's why we talk about it through pop culture, because no matter how strongly you may feel about Meghan Markle, your opinion is not under attack. You are not under attack. You might have real strong feelings about someone and how they've behaved or things that they've said. But at the end of the day, we can talk about defamation and talk about where the boundaries are of shit you can and cannot say. And at the end of the day, our lives aren't that greatly impacted. And so we can talk about it because it's worth having a conversation about. When it comes to other things, particularly other things in the news at the moment, we're still in the emotion of it. We're not to the critical thinking and nuance of it yet. So let's get to the critical thinking and nuance of this. I appreciate all of you and I hope it helps. But any of you that are like, I've gone through this thing and I want to share it. There are people who will greatly benefit from knowing that they are not alone. And that is the power of community. Y'all are the best. Let's talk about, I miss Judge Newman. So we're going to talk about Cousin Eddie primarily because I miss Judge Newman. And you understand that we need Judge Newman right now. I want Judge Newman to run for office. I would vote for Judge Newman for anything. Judge Newman, can you save us? Can you please? Can we all just agree? Can we all just agree? Please? We need more Newman. He's just so calm. He's like, I imagine when his kids came home when they were young and they were like, so I, ran out of gas in the car or whatever. He's like, how did that happen? How did we make that decision? Okay. So we understand where that decision got made and we're not going to do that again. Yeah. Yeah. Okay. Good talk. Like he's just such a calming presence. And I just adore him and I want him to do all of the things. So, Judge Newman, preside over everything. We need your calming presence. We need a TED Talk and a book. We need all the Judge Newman. I want to know his entire life story. I want a documentary on Judge Newman. I mean, I want to know so much more. So yes, we're going to watch the Cousin Eddie bond reconsideration hearing. It's about 20 minutes long. Here is the thing. If you have been following the Murdaugh case, let me swoop. If you followed the Murdaugh case on this channel or elsewhere, no shade, no judgment. The Murdaugh trial for the murders of Maggie and Paul were one piece of a very large, it's web of cases. We heard a lot about Cousin Eddie Smith inside of the Murdaugh trial. The fact that we did not hear more was super disappointing to me. I wanted all the things. I wanted to know everything. Cousin Eddie has received like hundreds and hundreds of, no, was it up into like 1.2 million? I think it might have been, but don't quote me on that because my trial notebook for Murdaugh is on the other side of my office. Cousin Eddie was receiving a ton of money from Alec Murdaugh. So when they were going through all those financial things and they were talking about checks going to Cousin Eddie, the forensic accountant for the grand jury guy was talking about 10 different iterations of Eddie Smith's name that were used to funnel money to Cousin Eddie. He has been charged alongside Alec Murdaugh in a number of drug and conspiracy and distribution charges. It is widely rumored that he was one of the people that was providing narcotics to Alec Murdaugh, and there's a lot more there. So this is one of the other webs, but I also want to know what Cousin Eddie knows. Cousin Eddie was looked at as a suspect in the murders of Maggie and Paul and cleared. He has given a couple different interviews that are available on the internet that you can go watch, where he talks about what he was doing the night of the murders and his alibi. But this will go to trial. And if this does, this is not going to be a trial like what we saw in Murdaugh, but we're going to learn a lot if this goes to trial, because he will probably go to trial separate from Alec Murdaugh. I want to know what Cousin Eddie knows. Where did all that money go? How did he get all that money? Why was Murdaugh paying him? What was it for? Where was it coming? The amount of questions I have. So many. So I want to know what Eddie knows. Cousin Eddie, you're going to do better if you tell them everything. It's not going to get worse for you. They want it to get worse for Murdaugh. Not legal advice. I'm sure your attorneys have talked to you. They want Alec. You are not the target. He's the target. Give them what they want. I mean, do what's best for your case. We're the internet and we're curious. All right, let's pull this up and get into it. So this is Eddie walking into court. And of course you see the attorneys sitting back in the back of the courtroom. That's John Metters sitting back there. So we've got the same group of attorneys on all of these cases. There's 99 plus indictments. So you've got all of these attorneys on these cases.
All right, please.
Hello, Your Honor. Different courtroom. So this judge is like riding circuit, which is why he's in a different chair. This judge is traveling with these cases from county to county to county. So the judge is going where the case is, which is wild to me. And his judicial assistant is going with him.
You may be seated.
Oh, I forgot to mention. Sorry. Thank you, chat. Cousin Eddie was also the one that was hired to shoot Alec Murdaugh. So he was me leaving out the biggest part of the story. So he was also indicted on the murder for hire / suicide for hire / insurance fraud case. And his story of how it all went down, as Bella reminded me in the chat, is super different than Alec Murdaugh's story. So that's the biggest part of the whole thing. And I forgot to say it. It's going to be like that today, apparently. So Judge Newman's tour of justice. Yes, he gets to bring his robe of righteousness with him. I saw another great question in the chat. These are all within South Carolina.
May it please the court. Yes, sir.
For those of you asking if that's a padlock on his back, yes, it is. He is shackled, so they're longer shackles, but he is shackled ankles to wrists, and then they wrap it around his waist, so he has some movement, but not too much. And no, his pants are not wet. That's just shadowing because his pants are looped. His pants are looped. So no, his pants are looped. So no, Judge Newman is riding circuit within South Carolina. So all these jurisdictions are within South Carolina. He's just in a whole bunch of different counties. And I imagine that some of those counties can be very dispersed distance-wise, but I don't know the topography of South Carolina all that well. There are palm trees. I know that.
Metters, Deputy Attorney General Don Zelink and Carson Burney here on behalf of
So Metters is in court.
Attorney General's office. This is the state of South Carolina versus Curtis Edward Smith, State Grand Jury Indictment 2022 GS 47-10.
There's a bunch of them.
This was a 12-count indictment. Judge, procedurally, he appeared before Your Honor on June 28th of 2022.
No, Metters, we missed you.
Initial bond setting.
I think.
Your Honor gave the defendant $250,000 bond, house arrest, GPS monitoring, several other standard conditions for the state grand jury. On August 11th of 2022, on state's motion, Mr. Waters appeared before Your Honor and asked that Your Honor revoke Mr. Smith's bond. At that time, Your Honor did revoke his bond. Your Honor, we are here today on behalf of his attorneys, Ms. Amy Zimmercheck and Jared Couchette, who have a motion to reinstate the bond.
Further defense?
Thank you, Your Honor. I'll begin briefly.
I'll
We
answer this
did
in a
file
minute.
a motion to reinstate bond. Mr. Smith has been in jail since the revocation hearing. As you can see physically, he has changed a lot. Probably since the last time you were in front of him, he's gained quite a bit of weight. He's had a lot of medical issues, Your Honor, and that we need to address.
Poor Eddie Smith. It's like he's got to go to court, and then they're like, just like, he's not been working on his summer body, Your Honor. He's got health problems. However, they are arguing to keep him out of custody. So I'm not surprised they're going to lean in because they are trying to keep him out of custody. So that is their argument. But y'all.
Additionally, Your Honor, he has been fully cooperative with the Attorney General's office in these matters. And And then I believe the rest of the information Mr. Bichette has about how many days he's been in.
Yeah, Your Honor, I would just point out, since the time of the revocation, it's been 235 days by my count that Mr. Smith has been incarcerated on these charges. As Ms. Zimmercheck said, he's been fully cooperative with the government. I don't think there's really any dispute about that, and we think that
That's what I wanted to hear. He has been fully cooperative with the government, and there is no doubt about that. So that's y'all. And with that, his attorneys are trying to say, look, this is why he needs to be out. Court is not easy at all. So that is not delightful. All right. So 235 days in custody, fully cooperative with the government. That's what we wanted to know.
that the lesson learned, for lack of a better term, that arose out of the revocation is not one that's need to be learned again. Eddie is fully committed to abiding by the letter of this court's
What did he
order
do to get
going
his bond
forward as we
revoked, though?
litigate these issues, and we just asked the court
Your Honor.
to reinstitute the bond that it did back in June of last year.
And Your Honor, we are prepared to say some other things if Your Honor would like to hear.
Yes, sir.
May it please the court. Judge, we wouldn't be back here and most respectfully asking you to consider that just for no reason. When I got involved in this case last year, and Mr. Zelenka and I reached out to his attorneys, Mr. Bichette and Mrs. Zimmercheck, and as a result of that, Mr. Zelenka and I both had several meetings with Mr. Smith before the trial. During the trial, I met with him in anticipation of his potential testimony in the case against Richard Alexander Murdaugh.
Yeah, a lot of anticipation matters. All of the anticipation.
Judge, he cooperated with both Mr. and Mrs. Zelenka and myself. Numerous interviews, numerous hours. No deal has been reached with Mr. Smith. I asked him, and Mr. Zelenka did, for his cooperation through his attorneys and through Mr. Smith. He agreed to do that. He was prepared to do that, I believe. And if he had been called upon, again, the decision was made not to call him, then there was an issue whether or not we may or may not need to call him in reply. The decision was made not to. But he fully cooperated with us throughout this process and was willing to testify if called upon. Based upon my years of experience, I think he would have testified truthfully. I did tell them, again, I didn't promise them anything except that I would take his cooperation into consideration and bring that forward to the court. After the trial was over, his attorneys approached us and said, would you be willing to consider reinstating his bond? I said I had to check, and I wouldn't be here before you asking you to put yourself in a position if I hadn't checked. I wouldn't do that to the court.
Wait, so
because we did check with all the
y'all are on
authorities
board?
and Attorney General's office. I've checked with law enforcement. They are aware of this proceeding.
So everybody's cool.
Lack of a better word, they trust our judgment.
Y'all are cool with it?
He was
Okay.
willing to cooperate, and I feel it's the right thing to do to ask Your Honor, respectfully ask Your Honor. And obviously, Your Honor, in revoking his bond, did the right thing. There's no question about that, and I am certainly not questioning that. Since that time, in my involvement with Mr. Zelenka, he has cooperated completely, and we are asking Your Honor to take that into consideration. And the state is asking Your Honor, respectfully, if you would reinstate his bond with the exact same condition.
If the prosecutor and the defense are all on the same page with reinstating Cousin Eddie's bond and letting him out of custody, then the judge is most likely going to let him out of custody. They're like, hey, we're not worried about him. He's got health stuff going on. Let him out. I wonder if now that Murdaugh is in custody, they are less worried about the safety of Cousin Eddie, and they haven't needed him to testify in the murder trial. They might need him to testify later. But part of the reason his bond was revoked was because He violated terms, but I think some of his bond being revoked might have also been for his safety. So, let's continue on. Pamela H said, why wouldn't they let him out if they all agree? Sometimes the judge doesn't agree, but we will see. I imagine when the prosecution and defense are in agreement, the judge is probably going to be in agreement. But this hearing happened a few days ago, so some of you already know the result. But I think now that the murder case is over, they're not as worried about it. But if he has health issues, they need to go ahead and put whatever he has to say on the record, on video. There are procedures in criminal law where you can do that. They need to lock it in if he is having health struggles now.
House arrest, GPS, monitoring, drug tests. If Your Honor feels it's appropriate, if you don't, Your Honor, no one respects you more than I do. But I'm just trying to put on the record and fulfill my obligation. I believe that I did promise in the exchange for their cooperation, I would tell the court, I think I'm doing what I promised to do.
Thanks, Metters.
I do want to highlight one thing.
We got it. You
His
are in
prior
agreement.
record. He was receiving stolen
Metters
goods
is
back in
absolutely
1985.
I agree with the wise
simple
court.
assault and battery in 2002.
I've definitely done that.
The only other involvement he has had in their pending charges are what he got involved with Richard Downs and Murdoch. Other than that, he has no prior record.
Now, Mr. Zaleka.
No, we speak with one voice on this, Your Honor.
If y'all agree and he wants out,
All right, December check.
Thank you, Your Honor. We absolutely appreciate the consideration and the consent of the Attorney General's office. I can't tell you how many hours of emails and telephone calls and meetings with Mr. Smith that I have had. He understands.
Send you emails.
Yes, Your Honor, from the jail. Quite honestly, it saves me the time going down there, so I love it. But Your Honor, the focus, I can tell you, the focus of our conversations have been how important it is that he understands exactly what this court is directing him to do. And Your Honor, his bondsman is here in attendance and prepared to, he's sitting here.
Where's that bondsman?
if you are arguing to have your client out on bond, having the bondsman in court is tremendously helpful to the court feeling confident about releasing someone from custody.
Benji Bill, sorry.
Oh my God, I love this man's suspenders and his bow tie.
Why are you here?
I was contacted.
Y'all, these suspenders are great.
Reinstating his bond, and I'm just here to put my side on him.
I adore this man.
He was in agreement, Your Honor, to remain on the bond if it were to be reinstated.
Is that right, Mr. Brown?
Yes, sir.
All right, thank you.
Sir,
And Mr. Smith understands the
I have seen a lot of bondsmen come to court in my day. I have never seen a bondsman with drip like that. Ever. Like ever. Your Honor. Just, we trust this man. It's fine. I love it so much. I love it so much. Gosh, I love it so much. South Carolina is very fun. This is delightful.
parameters of the home detention and the GPS monitoring, Your Honor, as well as
Chat,
all
I
of the other
see you.
conditions, no guns, anything else that the court felt like it had put in its order, and of course, anything else that the court may need to add. But Your Honor, at this point, we would just respectfully ask that you reinstate his bond.
Mr. Boucher, anything else?
Nothing further, Your Honor.
Mr. Smith, what do you have to say?
Yes, Your Honor. I understand the significance of these cases. It's time.
I love Judge Newman being like, Mr. Smith, I want to hear from you now. I'm here for it.
I am with Alice Murdoch, and I totally understand the importance of the letter of my bond. And when I get on my property, ain't nobody gonna drag me off. No breath. Thank you.
How many pounds have you gained?
Ma'am,
How
sir?
many pounds have you gained?
About 55. My sugar's off the chart, blood pressure's off the chart, so I mean, and I got titanium rods and screws in my back, and I have not been able to get any medical treatment for my pain for 8 months.
And all of that caused you to gain weight, or?
Yes, sir. Not be able to get any exercise. I'm used to working in the garden. I work all day. I enjoy work, and I haven't been able to do anything.
Anything further?
Nothing further from the defense?
No, sir, thank you.
So you're asking me to reinstate the bond with the
And he
same
was on
conditions?
his bond.
Yes, Your Honor.
And, the bond that was previously, ordered with a surety bond of the sum of $250,000, no 10% allowed. Defendant not to leave the state of South Carolina without permission of the court.
That makes
At the
sense.
request of the state and/or at his own expense, the defendant shall be subjected to drug tests and must appear at whatever facility designated by the state for drug testing.
I wonder if he's going to put
Shall
him on
have no
GPS.
contact with any co-defendant or witnesses, including victims or victims' families, if any.
No contact? Okay.
He does not have a current passport, his passport is expired. Shall not sell and encumber any property while on bond without permission of court. Must appear at all scheduled hearings and the trial. Must keep the clerk of the court, clerk of the state ranger advised of his current home address and phone numbers so that any notices can be sent if necessary. Mr. Smith understands that any future violations of any federal, state,
Yeah, if he violates it at all, they're going to put him right back in custody.
quickly.
Quickly.
Grounds for revoking.
Yeah, there will be a
the bond.
swiftness.
Defendant understands that he has a right to be present at the trial, and it's his responsibility to maintain contact with his lawyers and the court, such that he will be present whenever called upon to be present. And
Yeah, I
that
think the
the
judge
bond
said
must
no
be
10%, so a
issued
full cash bond.
in a matter prescribed or approved by the clerk of the court and the grand jury, must waive that condition. And he is placed on house arrest.
And then he'll probably have to pay for his own GPS monitoring while he's on house arrest. That's normally how that
Without
works.
exception, except to work, church, school, attorney, or medical appointments. And I think the last time, Mr. Smith, as I understand, you took that word to work. You interpreted that to mean that you could go any place you wanted to go as long as you said you were working.
But,
You ended up going all kinds of places.
yes, Your Honor, I went places I wasn't supposed to go without notifying anybody. Yes, sir.
So what kind of work do you consider yourself to be doing?
I'm a truck driver, diesel mechanic, working the logging woods, I haul chips from the paper mills, from the power plants to the cement plants. It's the same route every day.
So any work
That's why the GPS monitoring is important.
related travel must be approved by the court after notice through your lawyer and the state.
Yes, Your Honor.
So that any
That means you can't work
duration
this
of
week.
travel will
You
be
can't work this week.
included in the GPS monitoring so that everyone.
His attorney just told him he can't work this week because they have to notify everybody.
And you must pay for GPS monitoring at your own expense, which must be connected to the device upon your release from jail.
And that's part of why the
You
GPS
cannot possess any
monitoring is needed.
firearms. And you understand, if this bond is reinstated, Mr. Smith, there will be a strict compliance with it.
Yes, Your Honor.
No
Strict,
deviation, no
strict compliance.
leniency, no latitude in any way.
Yes, Your Honor. Totally understand.
Anything else?
No, Your Honor, we'll get you that work route this week, and we'll get it to the Attorney General's office as well.
There are microphones on council table, so that's what's picking up council.
Things to be reinstated.
But they know they're in open court on the record.
As I just stated, which are the same terms as before. Then secondly, concerning this case and the status of it, we're in the process of scheduling status conferences on all of these cases,
Yeah, when are those?
except Mr. Harpootlian has indicated his unavailability until the term of the legislature is on. First, but did not affect Mr. Smith and some of the other.
Even if Poot's not available, I'm sure Griffin is. There's two attorneys.
So have y'all come up with a date that you all want to have a status?
I believe, Your Honor, April 21st is what we replied to your clerk. That worked for, no, worked for both defense attorneys.
Yeah, Your Honor, I replied with whatever date, but we'll be
April 21st.
flexible. I don't recall what I replied to, but I know there were 3 Fridays in a row there.
We'll certainly check with everyone in the office and get back forthwith with Your Honor.
Those status conferences are going to be hard. There's a lot of cases in a lot of different counties. A lot of different counties. The deputies brought Eddie Smith a chair. They are letting him out of custody. He is in custody now. They are letting him out of custody on the same conditions he was in before. We'll talk about that in a minute. He will be able to work. He said he works as a truck driver. He'll be able to work, but he'll be on a GPS monitor. He'll have to take the same route.
Smith's case is pending in which counties?
Your Honor, Hampton,
Colleton.
I know that the majority of the cases that were revoked for bond were state grand jury cases, and then he has the additional,
The venue is in Hampton County.
right.
So the majority of his cases are in Hampton.
So that hearing will be set for Hampton County.
And,
So-
and I believe, Your Honor, that an order that you signed says that you have jurisdiction over all of those cases, so.
Yes,
I
but
think the
they,
venue's Colleton County, all due respect.
Oh, is it? Okay.
but
yeah,
they still
Colleton,
have to be
sorry.
in the same county. It's so confusing to me that their state grand jury has them all in
Yeah,
different
maybe
counties
in any of those cases.
instead of centralizing them in one place. But I'm sure they have a reason. It's so different to me.
Colleton, yeah.
Some cases are in Hampton, some are in Carlton. So,
All of the state grand jury are in Colleton, Your Honor.
and we'll
then the
talk
roadside
about
shooting are in
the other
Hampton, Your Honor.
questions I saw in a minute.
The roadside shooting cases, the charges that he had arise from that are in Hampton County.
That is the insurance fraud case with Alec Murdaugh.
Hampton County.
I think that's the next biggest case they have.
Yes, sir, Your Honor.
In this case, and the others may be someplace else, but Allendale, Orangeburg, Colleton.
It's a lot of counties.
We'll decide.
Yes, sir.
But they're all in the 14th Circuit, so
Can't you just centralize them
the
somewhere?
venue for most of them are 14th Circuit. But the next hearing will be in Hampton.
Yes, sir.
And Your Honor, just
And
one,
that's changed by the court, because I'm presiding in Richmond that week.
one thing, I know that the court may or may not be able to do anything with this, but we are certainly advising Mr. Smith not to speak with the press, and we would ask that they not descend on his house. I know that the court can't order because we have First Amendment, but we just wanted to make sure that we put that on the record as well.
Since you know they're watching,
Yeah,
smart of his
first one,
attorney.
Kind of hard to identify sometimes.
Yes, sir.
See how that goes. But you can make an announcement whenever you like.
Thank you,
She
Your
just did. She just said
Very good.
he's
Thank
not
you,
talking.
Willis.
Thank you, Your Honor.
Thank you, Your Honor.
Thanks, Your Honor. Oh, there's a few more minutes here as Eddie Smith leaves court. A number of you asked about medical care in custody. Medical care in custody is difficult. There is medical care, but chronic conditions tend not to get treated. They tend to
We're
deal
outside the Richland County Courthouse here.
with, and that's the rest of their news report. We are done with the hearing. That news report, I pulled the feed from Fitz News. So if y'all would like to watch the rest of their reporting on that, that is on their YouTube channel. But in custody, there is medical care. It tends to deal with urgent matters first. Care for ongoing and underlying health conditions are difficult and not always available just because limited resources. And so when you prioritize in order of importance, they prioritize things that tend to be urgent and more severe first, and then getting to something like a more chronic back pain or even helping manage blood sugar and things like that tends to get pushed down the road in order of importance as resources are available, which is one of the realities of being in custody. So it just, it looks like Eddie is just struggling, but also I don't know what they do with pain medications in custody. I think you might have to be in hospital to be administered pain medication, not in the jail facility setting, but it just depends. So he says he's not getting the medical treatment that he needs. And that, again, I've seen a lot of people saying I'm not getting medical treatment, but then you see the medical reports and they're not leaving to go to their doctor's appointments. So who knows what's up with that. But with Cousin Eddie, he will be out of custody pending all of his trials. And the status conferences, when they are set, we will check in on those. So when those are set, we will check on them probably later this month and into next month. So with all of that, are you all ready to talk about Meghan Markle? Let me give a quick summary first. A quick summary first. And Cousin Eddie needs to take care of himself. You know why? You know why? They're going to need his testimony. Yes, he's going to be on trial, but they're going to need his testimony. So with all of that, he's going to have to pay for his own, well, he's got a bondsman. So the bondsman will put up the amount of the bond and he will Cousin Eddie will deal with collateral for the bondsman to put up the bond. It looks like they're putting up the full bond. What else? So they're putting up the full bond, and then he will be on GPS ankle monitoring. He has to pay for that himself. So he will be paying for that. And then if there is a medical need, most jurisdictions have a procedure to allow them to have testimony taken in a case on video. Similar, it generally has a different name, but similar to a deposition, but it's used as trial testimony because you don't generally do depositions in criminal cases, but you can have interviews and testimony for medical need and get those on tape if somebody truly is not doing well. So with all of that, we are going to get to Markle v. Markle. Let me swoop. As we get to Markle v. Markle, just a reminder, the last time I covered this case, I was quite caught off guard by the amount of vitriol that went flying in the direction of Meghan Markle, which is, I guess, something maybe that shouldn't have surprised me, but it did. Because the law nerds are generally not vitriolic. I think when I put her face in the thumbnail, we get people swooping by the channel that are not regular law nerds that don't know how we do things. So here's what I ask when we are talking about the Meghan Markle versus Samantha Markle. We can absolutely have a conversation about who you believe and what they said and what have you, but we don't attack people's character. We don't do ad hominem attacks. We don't fillet people on things related to, you know, their personalities and what have you. We don't do vitriol. We do conversation. So we're going to talk about this order and this case. If you're not familiar with this case, Samantha Markle, the sister of Meghan Markle, I think half sister of Meghan Markle, sued for defamation. I covered that, gosh, Miguelina, I totally forget when. I covered that a while back and went through the initial filing in the case, and then it has been winding its way through motions in the district court in Florida. So it came up for motions to dismiss, and we're going to go into this. We can absolutely talk about whether you agree with the court, whether you feel like these statements could be defamatory or not defamatory. I think there's room for a whole lot of conversation with the feelings about the people being separated out. And I think that's a real good exercise for, you might want Meghan Markle to take the W or take the L, but we need to take a look at this case, whether you like someone or don't, because people can be polarizing and still be sued improperly. Look at Gwyneth Paltrow. Polarizing. A lot of people don't like Paltrow, don't like her company, don't like the things that she does, want her to just fuck off with the bone broth. But it doesn't mean she wasn't sued improperly. So same here. We need to evaluate this suit and what this judge did. And that's what we're going to do because we're law nerds and we can do hard things. Look, if we cannot spiral into vitriol about James Spears, we can do this, y'all. We can do this. So let us talk about defamation in the Markle v. Markle suit. I don't remember when this suit was filed. Hold on. I need to answer my own question real quick before we get into this. Microphone, you need to move out of my way so I can type. My son is very disappointed that I don't have a mechanical keyboard. He was like, I want to modify your keyboard. And I was like, yes, but then it would be higher and then it would be in the way. And so I have a membrane keyboard, apparently not a mechanical keyboard. So we can't modify the keyboard. So this case was filed, like a year ago. March 3rd, 2022 is when this case was filed in Florida for defamation. So this is the court's latest order. Let's go through this order on the motion, the motions to dismiss. Linda said, I will say I'm a big fan of South Park. Look, man, humor is one of the things that we need in the world. I talked about South Park getting sued. I need to check back in on that one too. All right. Markle v. Markle. Let's see what the court hath wrought for us today. This is a court order filed March 30th, 2023. So a month plus, or a year and a month since this case was filed. This cause is before the court on defendant Meghan Markle's motion to dismiss the first amended complaint, plaintiff Samantha Markle's response in opposition, and defendant's reply. I love a judge that just lays it out. For the reasons set forth below, the court will grant the motion to dismiss. So the motion to dismiss is granted in this case. We're going to find out why. Plaintiff's defamation claims based on the book Finding Freedom will be dismissed with prejudice. For those of you who don't know what prejudice means in these legal contexts, it's like malice has its own meaning in law, so does prejudice. In this case, dismissed with prejudice means permanent yeet. You cannot bring the claims again at all. That is done. It's the end of the world as we know it. Without prejudice means they can try to bring the claims again. Like, look at this order and see if you can bring these claims again. We'll see if the judge thinks that that's possible. It's kind of like the Nirvana Baby lawsuit where the judge is like, I'm dismissing this. You would need to do all these things. And then they refiled it without changing any of the things. And you're like, right, because you can't. So one claim based on the book Finding Freedom, dismissed full yeet. You cannot bring it again. The other remaining claims you might be able to bring again. We'll see if they do. But for now, the case is dismissed. Factual background, footnote 1. The following statement of facts is derived from the first amended complaint, docket 31, the allegations of which the court must accept as true in ruling in the instant motion to dismiss. The standard the court has to look at is, if everything that you said was true, assuming everything you said was true, do you have a claim? So that is where the court is coming from. All facts and assumptions need to be taken towards or for the non-moving party. Meghan Markle is the one who made the motion. Samantha Markle is defending the motion. Samantha Markle is the non-moving party. So the non-moving party, all the assumptions go in their favor. That is how the court decides this. Even if we assumed everything you said to be true, do you still have a claim? And for one of these claims, the court said not even a chance. The parties, Samantha M. Markle is a citizen of Florida and half-sister to Meghan Markle. As alleged in the first amended complaint, the two were close during childhood, and plaintiff regularly drove defendant to school and helped her with homework. Overall, they had a quote-unquote wonderful relationship. Plaintiff and defendant stayed close in the years that followed, even as defendant's acting career took off. However, their relationship soured after plaintiff met Prince Harry and became engaged to him. Remember, lawsuits are allegations and shade. And the court has to assume the allegations and shade are true for the purpose of this motion. Mariko, thank you. I've missed it too. From late 2015 to 2018, plaintiff and defendant did not communicate, which plaintiff understood to be a consequence of defendant's acting career and busy travel schedule. However, plaintiff soon realized that the relationship had, quote, unraveled. Defendant hung up on plaintiff during a phone call. Defendant hung up on plaintiff during a phone call, invited their father to the royal wedding before disinviting him due to his health, and ultimately did not invite any family members to the wedding. Plaintiff was contacted by the media for a story and stated that defendant should reach out to her ailing father. The press wrote that the plaintiff bashed the defendant and used fabricated quotes. Defendant responded to plaintiff through the media. Defendant being Meghan Markle, plaintiff being Samantha Markle. Samantha, we'll just go Samantha and Meghan. Samantha was later interviewed in December 2018 and received negative press coverage. Okay. Sometimes the press does that. Finding Freedom, Meghan and Harry, and the Making of a Modern Royal Family. On August 11th, 2022, a book titled Finding Freedom was published and marketed as defendant's, Meghan's, unauthorized biography. It was written by Omid Scooby. Even if that's not pronounced Scooby, it's spelled Scobie, and I'm pronouncing it Scooby. And Carolyn Durand, as distributed by HarperCollins. Although the book was supposedly, quote, unauthorized, plaintiff Samantha alleges that Meghan contributed false information to the book through her agent and communications secretary. How many chat, play with me, chat. How many levels of hearsay do you see? Hold on. So the book was written by Scooby and Durand. It was unauthorized, but they're alleging that Meghan gave the writers of the book false information through her agent and communications secretary. Generally, you have to sue the speaker of the thing, which is what is happening here. Samantha is alleging that Meghan Markle's the speaker of the thing, even though it went from Meghan to agent and communications secretary to writers. So we've got like 2 levels of hearsay, which is wild. So Samantha speaking to, or Meghan speaking to the publications and agent communicators is kind of hearsay to them, even though they're hearing it directly from her. And then from them to the authors is like 2 steps of hearsay. It's a lot of hearsay. It's a game of telephone. Samantha further alleges that chapter 12, titled A Problem Like Samantha. How do we solve a problem like Maria? Every time I see this chapter title, that's what I think of. Don't you? Titled A Problem Like Samantha contains numerous false statements about Samantha. Samantha lists the following 7 statements from the book. These are the ones that have been removed and cannot be brought again. So we're saying goodbye to all of these allegations. Allegation number 1. Samantha and defendants, quote, paths had crossed only twice since they grew up. Tell me how it's defamatory. Tell me now. Chat, help me the fuck out. Help me out. How is it defamatory? Their paths have only crossed twice since they grew up. Find me the defamation. Help me understand. Help me help you. 2, there was only one picture of plaintiff and defendant together. How is it defamatory? Let's get to any that we think are defamatory in this. It might be untrue. It might be untrue, but untrue doesn't mean necessarily defamatory. Even if it's untrue, I mean, it might be a lie in the unauthorized biography that I don't know if we can prove to the standard of a court of law that she participated in. Maybe she did. I hope that everyone in this is able to just, I don't know. I wish you well. Let's go to number 3. Plaintiff reached out to the Sun with her story about how snagging a royal had been Meghan's lifelong ambition and was, quote, handsomely paid for this. Okay. 4, Meghan didn't grow up with Samantha. She barely saw her. 5, the half-sisters have never been close. 6, Samantha was not invited to Meghan's first wedding. 7, Meghan, quote, asked her father to intervene with Samantha, and he had told Samantha she is hurting Meghan. None of these seem defamatory to me. Even if they are lies, I don't think they are going to be reputationally damaging in a way that can be proven. Those statements, when we look at those statements, and when when we did the complaint, the emails with it might have been the press secretary or the communication secretary were attached to that. So even if we assume that all of those are lies, I don't know how we get to defamation. I mean, how do those touch on reputation or character? I guess you could, and the court doesn't see it either. Maybe you could argue that saying that she was paid for interviews goes to her character, but character for what? I don't know. All right. These are a stretch for me. Even if you don't like Meghan, these are a stretch. Defendant's CBS interview. On March 7th, 2021, Oprah Winfrey interviewed defendant and Prince Harry on a televised CBS special. Now, when you have the defendant speaking about the plaintiff directly, if that's what happens here, we're in a bit of a better position to bring a defamation suit than saying, but she told so-and-so to tell so-and-so to tell so-and-so that we weren't close growing up. It's different. Defendant's CBS interview on March 7th, 2021, Lord, can we talk today? Oprah Winfrey interviewed defendant and Prince Harry on a televised CBS special. I didn't watch that special. I went to try to find it a year ago when this was filed, and it's gone. Like, I couldn't find it anywhere. Over 50 million people tuned in worldwide. I was not one of them. And now I can't find it anywhere. It's just whoosh, gone, which says a lot to me that Oprah took it down. Over 50 million people tuned in worldwide. Plaintiff alleges that defendant made 3 defamatory statements on the interview. That she was an only child, had only met plaintiff a handful of times, and that Samantha changed her surname to Markle after defendant started dating Prince Harry so that she could cash in on her newfound fame. So with that, I think the only child statement is probably not defamatory. The met a handful of times is probably not defamatory, but plaintiff changed her surname to Markle after defendant started dating Prince Harry to cash in on fame might start to get you there. Might start to call character and reputation into question. Perhaps. Plaintiff submitted an undisputed transcript. Oh, there's a transcript. Emily says the interview is up on YouTube. I'm going to have to find it. I looked for it. I'll look harder. If any of you see it, just email it to me with the YouTube link. That would be super appreciated. Okay. Undisputed transcript. Love a transcript. This is the pertinent portion of the interview. The alleged defamatory statements are underlined. Footnote 2. As the court will address infra, the second statement that defendant only met plaintiff a handful of times is not in the transcript, nor is a portion of the third statement. Well, that's not helpful. Speaker 3, CBS reporter, but she found out her dad was working with the tabloids. Defendant Meghan Markle. There was such an obsession about anything in my world, including tracking down my parents, and I did everything that I could to protect both of them in that media frenzy. But for over a year, the UK tabloids were trying to find my dad, offering people so much money to try to find his address. Once they did, I remember being told there was a huge headline like, "We found him," or "We've got him," saying that about someone's father. And from that point, the tabloids, they moved into an apartment next door and across, which one? And across from him descended on the small town, which is giving him gifts. The whole thing brings us to where we are today. Oprah Winfrey. I can't talk today. Oprah Winfrey. Did it feel like a betrayal when you found out your father was working with the tabloids? Defendant Meghan Markle. I'm just trying to decide if I'm comfortable even talking about that. If we're going to use the word betrayal, it's because when I asked him when we were told by the comms team, this is a story that is going to be coming out, which, by the way, the tabloids had apparently known for a month or so and decided to hold it until the Sunday before our wedding because they wanted to create drama, which is also a really key point in all of this. They didn't report the news. They created the news. We called my dad and I asked him and he said, no, absolutely not. And I said, you know that the institution has never intervened for any, that's a whole separate issue, but has never intervened for anything for us. But they can try to go in and kill this story. But if they do this once, we're not going to be able to use the same leverage to protect our own kids one day. Oprah. He said, no, absolutely not. He hadn't been talking to them. Meghan Markle. Yeah. Oprah. So he basically lied to you. Meghan. Well. And so when I said we wouldn't be able to protect our own kids one day, and I said, I just need you to tell me. And if you tell me the truth, we can help. And he wasn't able to do that. And that for me has really resonated, especially now as a mother, you know, Oprah, not being able to, not being willing to protect you. Defendant. And also me saying just full stop. If we use this to protect you, we won't be able to protect our own children one day. I don't understand any of this. I don't understand that whole, I don't understand any of this. Like, why won't you be able to protect your own kids if you try to kill this story? I truly don't understand that. I don't think the British tabloids are in the right, but I just don't understand that point of it. I don't understand the logical theory. But I also don't understand how any of this works. Okay, so back to the interview that we are now recreating through this legal filing, because this is in the court's order. This is in the court's order. Like, if we protect, Megan is telling Oprah, if we protect if we protect dad and kill this story, that we're not going to be able to protect our kids one day. I don't know. Is it like the extra life coin that you get in a Ready Player One? You only get one? I don't understand. But I do understand about the royal family not generally helping in things like this and just letting it happen. But that aside, defendant said, and also me saying, just full stop, if we use this to protect you, we won't be able to protect our own children one day. Well, I'm talking about your grandchildren, so I can't. I mean, look at Archie. I think about this child and I go, I can't. I genuinely can't imagine doing anything so intentionally to cause pain to my child. I can understand that. A lot of people have had that experience. When you look back at parents and parent choices and you're like, I don't know if I understand that, because I don't think I can do that. But I don't understand it in this context. She said, I can't imagine it, so it's hard for me to reconcile that. It seems like Meghan Markle at this point in the interview has talked about her dad betraying her and not about killing the press story. That seems to be more about, I can't imagine lying to your own kid. That's what that seems to be about. This is confusing. Okay. Oprah. So your father being hunted down, it seemed like you were saying in some ways that they did this to him. So I want you to be able to clarify this, that the tabloids, the media did this to him. They hunted him, but he has a responsibility in it too. Meghan, everyone has accountability. Look, they've hunted my mom down. Oprah, right? And she never speaks to the tabloids. Meghan, I never heard her say a word and remained in silent dignity for 4 years watching me go through this. Oprah, and Samantha Markle, your half-sister on your father's side, has written a supposed tell-all book about you. What is your relationship with her? Defendant, I think it's... this is a transcript. I think there's a has in there, but I think it's very hard to tell all. It's very hard to tell all when you don't know me. And it's this very different situation than my dad, right? When you talk about betrayal comes from someone that you have a relationship with, right? I don't feel comfortable talking about people that I really don't know, but I grew up as an only child. Okay. Which everyone who grew up around me knows, and I wished I had siblings. I would have loved to have had siblings. So I'm excited to be pregnant, that Archie has someone. It was really interesting to me. The last time I saw her must have been at least 18, 19 years ago. Before that, 10 years before that. Oprah, so you all weren't close. You didn't grow up together. Meghan, no. Oprah, she doesn't really know you. Defendant, no. She changed her last name back to Markle, and I think she's an early 50s at the time, only when I started dating Harry, and so I think that says enough. So not saying directly she's cashing in on it, but implying that she's cashing in on it. Speaker 3, CBS reporter. That name change does say a lot. Oprah is still with us. Oprah, the other thing that leapt out to me was the way Meghan described how her mother had been bearing up under all this scrutiny with, quote, silent dignity. And then you contrast that with her father. Is she open at this point to having a relationship with her father? I know he's never met Archie or Harry. Oprah Winfrey. I know, or Harry. I think I haven't really, I didn't pursue that conversation with them. From what I gather, her relationship with her father is similar to what's happening with Prince Harry and Prince William now that there is a distance there. And maybe with time, things will get better. So here's what I understand, and here's what I don't understand. This is a defamation suit. This is a defamation suit between Samantha Markle and Meghan Markle for Meghan Markle lying about the fact that she's an only child. Though I think you could also argue that can be interpreted as she is her mom's only child and she is, I don't know, what, like 15 years or 17 years between the two. So even though she had an older sibling, that older sibling was so much older that it didn't really seem like she had a sibling. I think there's room to argue that that wasn't meant that she literally didn't have a half sister, but that she grew up as an only child. I think there's room for nuance there. And I saw the chat talking about the British tabloids. I understand that the British tabloids can be appalling, but I don't understand the conversation about if we protect our dad, we can't protect our kids. That's where I got a bit lost in it. I'm not lost in the reason you would want to protect your family from the tabloids. I'm lost in the you only get one kind of a thing. That's where I was lost. I'm not lost in that they feel that the royal family didn't help kill stories for them or protect them. That I understand. I get their feelings on that. But it says very clearly here, but I grew up as an only child. How is that defamatory? I don't know. So I don't think I grew up as an only child is defamatory when your sibling is like 17, 15, whatever years only older than you. It's just not defamatory. It's her experience. And I don't think it's reputationally damaging to Samantha, who's substantially older. I mean, having a sibling when you're in elementary school and your siblings in their early 20s, they're not quite your sibling. They are your sibling, but the relationship is not as if you had somebody that was a child your age. It's as if you have another caregiver who's just younger than your parents. Okay. And then she changed her last name back to Markle, and I think she's in early 50s at that time, only when I started dating Harry, so I think that says enough. That's a very different statement than the allegation that, and the exact words matter, that plaintiff changed her surname to Markle after defendant started dating Prince Harry so that she could cash in on newfound fame. Those are very different words. Cashing in on newfound fame and that says enough are different words. Sandra Ramirez, I see your chat. Thank you. Words are hard for me today too. Look, it was a full moon yesterday. Sometimes things get rattled. All right. Let's talk about damages. Yes, please. Let's do a quick reminder. Defamation, you need to have damages. So what are the damages here? Plaintiff lives in Lakeland, Florida, a small town where she is well known. She alleges that as a result of the false statements, defendant's quote-unquote fan base, including a significant part of Lakeland's population, became angry with plaintiff. Suddenly, plaintiff was seen as an opportunist trying to cash in on her sister's success and fame, despite having no relationship with her. The defamatory statements caused irreparable prejudice, injury, and harm to plaintiff's reputation. And defamation is really about reputation, as well as anxiety and emotional distress. She has received hate mail, ongoing negative press, and was stalked by one of defendant's fans. Well, that shit's never okay. Don't stalk people. Look, y'all, I'm yelling into the void with the law nerds. Y'all know this. The internet doesn't need to go real world. And it's also okay to have opinions that you don't like someone, and you don't need to tell them that. No need to send them hate mail. You can think that. There's no need. There's no need to take that to them. And the negative press, I don't think there's a lot you're going to be able to do about. Moreover, plaintiff has been unable to work as a mental health counselor because of the damage to her reputation. That part is probably more actionable because defamation lawsuits cannot fix all the harm. Cannot fix all of it. Wait, Candace Underfield, you're distantly related to Dolly Parton. You're famous to us. It's like Attorney Bueller, whose cousin is Ferris. That was a joke. This probably isn't. I'm not going to change my name to Parton simply because she's famous. However, we would support you if you did. But this part is where you start getting into the real world damages. If you cannot work your job because of what has happened, that is a problem. Ippy Fluffy said, I'm distantly related to Ringo Starr. That's a whole different conversation. I can't go. We'll talk about Ringo later. I love seeing who y'all are related to. Chat, I know it's not on topic, but feel free. Just feel free. Feel free to drop all those tangential relations in. We're here for it. Roy Hardy, that's funny. All right, let's keep going. Judicial notice. The court granted defendant Meghan Markle's request for judicial notice in support of the motion to dismiss at a hearing on February 15th, 2023. Thus, the court takes judicial notice of A, the existence of Chapter 12 of Finding Freedom written by Scooby and Durand, B, two New Mexico state court documents involving plaintiff, 3, the fact that Prince Harry announced that he was dating defendant on November 16th. These are all proper things to take judicial notice of. You don't have to prove that he announced it. Everybody just can agree that that happened. And C, the fact that Prince Harry announced he was dating defendant November 16th. All right, the parties agreed that the court could consider the transcript of defendant's CBS interview, which plaintiff attached to her initial complaint, and her response to the instant motion. Legal standard to survive a motion to dismiss under FRCP 12b6. Failure to state a claim. A pleading must include a short and plain statement of the claim showing that the pleader is entitled to relief. Labels, conclusions, and formulaic recitations of the elements of a cause of action are insufficient. Mere naked assertions are like a naked mole rat. Mere naked assertions are also insufficient. A complaint must contain sufficient factual matter, which, if accepted as true, would state a claim to relief that is plausible on its face. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw a reasonable inference that the defendant is liable for the misconduct alleged. The court is not bound to accept as true a legal conclusion stated as a factual allegation in the complaint. Overall, the complaint must give the defendant fair notice to what the claim is and the grounds upon it rest. In ruling on a motion to dismiss, a court is generally limited to reviewing what is within the four corners of the complaint. Just the shit you put up in the complaint. That's it. However, it may also consider attachments or exhibits provided with the complaint. And then they can take judicial notice of facts. Defamation. The substantive law of Florida applies to plaintiff's defamation claim. And then they cite this case with a footnote regarding the Turner case outlining what they're going to say next about defamation. Florida law separates defamation into two causes of action, libel and slander. Not all jurisdictions do this, some do. Slander is spoken, libel is written. Keep reading. Libel is defamation expressed in print. Slander, on the other hand, is, quote, a spoken or oral defamation. Oral defamation would be a fantastic name for a band. I want credit if somebody takes me up on it. I'm teasing. I don't really care. I just want someone to name a band that. Spoken or oral defamation of another. My son has been listening to the oral cigarettes, and I was like, are there other kinds? Like, why oral cigarettes? Why is that the band name? Sorry. The ADHD just spiraled. But oral defamation, definitely a punk band, right? I think so. Or if the guys from South Park formed a band, maybe they could name it oral defamation. Maybe oral defamation is a flavor of Beaver Moon Lager. Maybe that. If I ever name a whiskey. Oh, bingo. That's even better. I love it. All right, we are moving on. Is that lawful law? Yes. Is that the pickle's name? Ooh, maybe the pickle's name. All right, let's continue. I'm never going to make it out of this case. Isla X, oral defamation is the, quote, I have other uses for your throat. That needs to be their first song. MB said, I love all the famous ancestors. I do too. I love seeing it in the chat. They have Trey Parker and Matt Stone both play instruments and actually wrote the music for the Book of Mormon. I knew they wrote the music for the Book of Mormon. I need them to also have a band named Oral Defamation. A lot of lawyers have bands too. Creighton. We have, if you ever want to start another band, Creighton. Oral Defamation. With oral cigarettes, I think it's oral, ORAL, but I don't know. I don't know. The music my kid listens to, there are times I'm just like, what? But Oral Cigarettes is a Japanese band that he really enjoys. Let's see. No, ORAL. The Oral Cigarettes. That is what that is. I had to Google, as you can see. All right. Let us continue. Let me pull this back up without it getting crazy. Oh no, wait, where's my motion to dismiss? I lost it for a minute. We are back now. All right. Sorry, oral defamation. We're back to oral defamation of another, which is published to others and which tends to damage a person's reputation, ability to conduct a person's business. That's where I think we are in this case, right? Whether or not these statements have damaged the ability to conduct a person's business. And it seems that it might have, or business or profession, and which holds that person up to disgrace and humiliation. And this is each state's statute are written a little bit differently, right? So with the statute being written a little bit differently, you can see why Samantha Markle included the hate mail and the stalkers and the way people have treated her, because she has been held up to disgrace and humiliation. And that's part of the cause of action here. Either form of defamation requires the same elements. 1, publication. We have publication here. 2, falsity. 3, that the actor acted with knowledge or reckless disregard as to the falsity of the publication on a matter concerning a public official, or at least negligently on a matter concerning a private person. So there's some argument whether or not there is a private person here and whether malice is required, and that's the malice element, right? Knowledge or reckless disregard is your malice element for public figures. Actual damages, and that the statement was defamatory. A statement is defamatory if, so this is the test that we're all looking at for these. A statement is defamatory if it tends to harm the reputation of another by lowering him or her in the esteem of the community, or more broadly stated, is one that exposes plaintiff to hatred, ridicule, or contempt, or injures her business or reputation or occupation. When you're looking at it through that lens, does it change how you feel about some of the statements we've talked about? Let me know in the comments and let me know in the chat. Did these statements hold Samantha Markle up for hatred, ridicule, contempt, or injury to their business or reputation? Whether a statement is one of fact or opinion, and whether a statement of fact is susceptible to defamatory interpretation, are questions of law for the court. So the court gets to decide opinion or fact, and can it be interpreted as does it have a defamatory interpretation? Which means, is it not defamatory maybe on its face, but it is defamatory by that, by interpretation. In answering these, my brain has stopped. There's a more eloquent way to say that. In answering these two questions, the court must construe statements in their totality with attention given to any contrary terms used by the publisher in qualifying the statement. Finding freedom. Defendant argues that the claims based on finding freedom must fail because she did not publish the book. The court agrees. She is not the speaker. Meghan Markle, in this. In the amended complaint, plaintiff alleges that, quote, the false information contained in the book came from the Duchess herself through her agent and communications secretary. According to plaintiff, this allegation satisfies the publication requirement. Samantha also argues that Meghan's cases on the issue of publication are distinguishable. Finally, did she publish it? And this is what we saw in Depp Heard, right? Talking about, was it a tweet, a quote tweet, a retweet? Was the headline published by Amber Heard? Was the book published by, were the statements published by Meghan Markle? And the court is saying, nope. Plaintiff also argues that Meghan's cases on the issue of publication are distinguishable. Finally, at the court's hearing on this motion, Samantha argued that the claim for defamation under the theory of reasonable foreseeability of third-party republication is allowed under Florida law. That's a long way to go to get there. As discussed below, the court finds that the plaintiff's claim relating to finding freedom are due to be dismissed because 1, the defendant must publish a defamatory statement for it to be actionable, and 2, it's undisputed that defendant did not publish finding freedom. So the court isn't even getting to the issue of whether or not the statements in finding freedom are defamatory. She didn't publish the book. That's not a published statement. Be gone. And that is why it's dismissed with prejudice. You can't bring it again. As a matter of law, you cannot sue over this. So that's why it's here. And courts will often do this. When they can get to the first element first, they're not going to decide if these statements are or are not defamatory. They're going to decide that they weren't published and yeet it that way. They are always going to look really for the procedural first without deciding the factual matters, in my experience with judges. And this is more of the procedural. Was it published by Meghan Markle? No. Yeet. The court has taken judicial notice of the existence of the chapter. Defendant submitted a scanned version of that chapter as well as the title page and copyright page of the book. The authors on the book are listed as Scooby and Durand. Plaintiff concedes that they wrote the book. Publication is an element of defamation. As the Florida Supreme Court has explained, quote, because the publication of a statement is a necessary element in a defamation action, only one who publishes can be subject to this form of tort liability. So I wonder if under this law in Florida, you get much different results in Depp v. Heard. Because Amber Heard was the speaker in giving an interview, but the Washington Post was the publisher. So I'm really interested in this this case, Doe v. AM Online, because who published it? But then again, what they argued in Depp v. Heard is that Amber published it when tweeting it, and so that was that counted as a publication. So it's really interesting whether or not that would count under this case law, because the case law in Virginia is different. So these are again the questions that your brain goes through. Is the I wrote this article sufficient? Maybe. So the law in Virginia different than the law in Florida, and this is why having lawyers that help you pick a jurisdiction is so important. This is the shit lawyers do all day, is parsing the splitting hairs of what does publication actually mean. In this case, it says discussing the definition of publisher and a negligence action involving distributor liability, which is indistinguishable from garden variety defamation. Defendant Meghan Markle relies on Johnson versus Darnell for the proposition that, quote, a valid claim for defamation under Florida law would need to allege that the defendants themselves were responsible for publishing the defamatory material. I also think there's room to argue in like a Depp v. Heard that when the party is working with the publication and seeking to get it published, there's argument to say they published this. Very different than this case where it seems like maybe in a roundabout way that some information was provided from Meghan Markle to the publishers, but Meghan Markle wasn't working on publishing this book. So defendant relies on Johnson versus Darnell that a valid claim for defamation under Florida law would need to allege the defendants themselves were responsible for publication. Plaintiff attempts to distinguish Johnson by arguing that the defendants in that case indirectly led to the material being published, while defendant here was the direct source of the information. That's the argument. That's the direct source you're going to get, or argument you're going to get in like a Depp v. Heard case. In Johnson, an individual was pulled over by the police. He drove off during the traffic stop and later abandoned his car. This is not your typical fact scenario for a defamation case. This is a police chase. What is happening? Police discovered the car and found Johnson's driver's license inside the vehicle. That happens a lot. The officers who conducted the traffic stop, who conducted the initial traffic stop, identified Johnson as the driver based on the license and their recollection of the encounter. They filled out a warrant application and a warrant was issued for his arrest. Furthermore, his name and picture were posted on the county's most wanted list. The state of Florida ultimately chose not to prosecute Johnson for the offense, and he brought a defamation claim against the officers, arguing that their fabricated warrant application led to his name and photograph being published on the most wanted list. Well, that's a really interesting fact scenario. The trial court dismissed the claim based on Johnson's failure to allege publication. Oh, well, that's a mistake. You have to allege all of the elements. The 11th Circuit affirmed, holding that because he alleged that the officers indirectly caused his name and picture to be published on the list, not that they published it itself, or not that they published the list itself, he failed to state a claim. Oh, that would be really frustrating to be like, what? John Doe in the chat said, so in Florida, there isn't defamation and slander. Defamation only applies to libel. No, it applies to both, but the element of publication has to be there, whether you publish it in a written form or in a oral form, video, audio, radio, those types of things. It's a good question. Thank you. Plaintiff attempts to distinguish Johnson. I'm sorry. It was the oral defamation that got me to distinguish Johnson in this case. I made a really inappropriate joke the other day too. We'll talk about that in a minute. Plaintiff attempts to distinguish Johnson. It was at my kid's band parent meeting, and I was like, this is why I'm not allowed to play well with other parents. Plaintiff attempts to distinguish Johnson. I am a child. I apologize. By arguing that while Johnson failed to allege that the officers published the defamatory material, she alleges that defendant was the one responsible for the statements and finding freedom. I see where the court's going with this. This is a distinction without a difference. It's not a distinguished Johnson. This is a distinction without a difference. Plaintiff alleges defendant relayed defamatory information to her agent and communication secretary, who passed it on to the authors, who ultimately included it in their book. But this is not the same as claiming the defendant published the book. Thus, Johnson is persuasive. Do we name the pickle Persuasive Johnson? Plaintiff also tries to distinguish Clayman versus City Pages. We're not going to go through that case. Oh wait, I saw a blogger. Hold on. The plaintiff and Clayman sued a blogger named Ken Avador, among others, for defamation. His claim against Avador was based on a news article that Avador was the source for, but did not write. Avador did, however, email one of his blog posts to the author, and he was credited as the source of the alleged defamatory information in the article itself. The article also quoted him directly. Nevertheless, the court held that Avador was not liable for any statements in the article because he did not publish it. Here, plaintiff similarly accuses defendant of providing information that was later published by someone else. That's interesting. So even in that case where the source was quoted, the source wasn't determined as being the person who defamed her. Or defamed the defendant. Defamed the plaintiff. Sorry, that's interesting case law. But this case makes it even clearer that plaintiff has not sufficiently alleged publication. Finally, at a hearing on this motion, plaintiff's counsel argued that Florida law recognizes defamation claims based on third-party republication. Specifically, he claimed that plaintiff can satisfy the publication requirement by alleging that defendant passed along the information. Plaintiff's counsel relied on Granda Centro versus Laura in support of this proposition. The court is not persuaded by the argument. So third-party publication is not going to work. The court is not persuaded by this argument. Oh, I saw this question come up a lot, and I'm going to grab it. Where did it go? Elong, I'm grabbing this statement. I'm going to talk about this when we get to the end of this, when we get to questions. The court is not persuaded by this argument. Apart from a few outlier cases, Florida law does not recognize defamation claims based on third-party republication. Florida would have a different circumstance for Depp v. Heard, I think. That would be an interesting thought experiment. What would happen if Depp v. Heard was filed in Florida, or the similar fact pattern was filed in Florida? And the lower court itself only mentioned this concept in passing. Specifically, it stated in a footnote that there was evidence in the case suggesting republication of defamatory statements by a third party. It asserted that where there is such evidence, the defendant is liable only if the republication was reasonably foreseeable, which is generally a fact for the jury. Since then, at least 3 courts in this district have explicitly refused to adopt LARA on the basis that the footnote was mere dicta. Mere dicta means it's not controlling. It's an explainer statement, but it's not like controlling law. When we talk about splitting hairs, it's literally all of what law school is splitting hairs on case law. This is the kind of shit that I love, but it gets deeply nerdy very quickly. So the other courts have considered this issue and said, no, third party republication is not what we're doing. This court agrees the plaintiff's claims as to the statements in Finding Freedom will be dismissed because she fails to allege that Meghan Markle published them. Rule 15 of FRCP provides that the courts should freely give leave to amend when justice so requires. Despite this generally permissive approach, the district court need not allow amendment, which means you can yeet permanently. Cannot allow amendment where 1, there has been undue delay, bad faith, dilatory motive, or repeated failure to cure deficiencies by amendments. 2, allowing amendment would cause undue prejudice to the opposing party. Or 3, the amendment would be futile. That's where we are now. We're in the futile realm. There's no change in facts here that's going to allow them to argue that Meghan Markle published the book. Meghan Markle didn't publish the book. It's futile. And that's what the court rules. Another good pickle name, mere dicta. Dilatory dicta, maybe. Distinguished dicta, perhaps. The CBS interview. Plaintiff's remaining 3 claims are based on statements from the defendant's interview with Oprah Winfrey. The court will address each one in turn. Statement 1, Oprah Winfrey. And, oh, we've got to go back into voices. Hold on. La, 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 la. Oprah Winfrey. And Samantha Markle, your half-sister on your father's side, has written a supposedly tell-all book about you. What is your relationship with her? And then you go through it. All the statements said before. But I grew up as an only child. The amended complaint alleges that defendant, Meghan Markle, falsely stated she was an only child. Defendant contends that she, in fact, said she grew up as an only child. Yeah, that's a big difference. That this statement is protected opinion, and that's how she feels about her own childhood and is not falsifiable and therefore not actionable. Remember, the statement must be false. Plaintiff responds that this statement was one of fact and that it made, quote, it apparent that she was an opportunist of the worst kind. I love this court's writing. This, they said this, they said this, they said that. So easy to follow. Statements that cannot reasonably be interpreted as stating actual facts about an individual cannot support a cause of action. Likewise, opinions cannot be defamatory. Although pure opinions are protected, mixed expressions of opinion are not. The test for determining whether statements are protected opinions is whether, quote, the statements are capable of being proved false. You can't prove opinions true or false, right? Opinions with no provable false connotations cannot support a defamation claim. In determining this basic question, well, you can determine if someone's an only child or not, or if they grew up as an only child or not, right? You can prove that. In determining the basic question of whether certain language is defamatory, the words used are not to be construed or taken in their mildest or most grievous sense, but should be construed as the common mind would understand it. After making this determination, the court can dismiss a claim if it finds that an alleged defamatory statement is not actionable. Here, a reasonable listener would not think that defendant was suggesting she has no half-siblings. So the court says here, a reasonable listener would not think that defendant was suggesting that she has no half-siblings, that plaintiff does not actually exist, or that plaintiff is not related to her. Nor does plaintiff argue that defendant's statement would be understood this way. In determining whether an well, then why are you arguing it? In determining whether an allegedly defamatory statement is an expression of fact or an expression of rhetorical hyperbole, context is paramount. With all things, all of the circumstances surrounding the publication must be considered. A reasonable listener, and this is the court, a reasonable listener would understand it. Defendant merely expresses an opinion about her childhood and her relationship with her half-siblings. Thus, the court finds the defendant's statement is not objectively verifiable or subject to empirical proof. Plaintiff cannot plausibly disprove defendant's opinion of her own childhood. It's like my opinion. Cue Tara in the chat. I need a sound drop of Tara screaming at the reunion. It's like my opinion. It's like my opinion. Plaintiff cannot plausibly disprove defendant's opinion of her own childhood that she, quote, grew up as an only child and wished she had siblings. Because the statement is not capable of being proved false, it is protected from a defamation action. Therefore, the court is justified in dismissing the claim. That claim, I don't see how they revive. The court said, as a matter of law, it's opinion. Tamara, oh, you're right. Did I said Tara, didn't I? Words are hard today. I meant Tamara. Thanks, chat. I meant Tamara. Considering the permissive language of Rule 15, and because plaintiff has not had an opportunity to amend after an order of the court analyzing her claims, this claim will be dismissed without prejudice. I don't know how you fix this. Although the court questions plaintiff's ability to state a claim for relief based on the statement, plaintiff will be given one final opportunity to replead if she so chooses. Footnote 6. In deciding whether to replead any of the claims relating to the CBS interview, plaintiff should be mindful of Rule 11 of the FRCP. The court's like, think real hard before you bring this claim again. Think real hard. Or pick a different jurisdiction. Statement 2, CBS interview. And then you'll have to argue jurisdiction. I wonder if California would be a more friendly jurisdiction, because the interview took place in California. I think there's an argument that California could be a proper jurisdiction, and then you would go through the anti-SLAPP procedure, not this. I don't know if it's worth the money, though. According to the amended complaint, this is statement 2. According to the amended complaint, defendant told Oprah Winfrey that she had only met plaintiff, quote, a handful of times. However, this statement is nowhere to be found in the interview transcript. According to plaintiff, it was paraphrased from the following statement. Defendant, the last time I saw her must have been at least 18, 19 years ago. Before that, 10 years before that. Defendant argues this claim should be dismissed because 1, the statement is not in the transcript and was not said. 2, the term handful is too vague to be subject to an objective measurement or falsified. 3, it is substantially true that the two have only met a handful of times. And 4, the statement is not capable of being defamatory. Plaintiff concedes that the amended complaint does not accurately quote the transcript. Well, fucking hell then. Look, man, I understand that this relationship has gotten real contentious and has had a lot of negative impact for Samantha Markle. But what you need is the amended complaint to accurately recite what happened. Plaintiff concedes that the amended complaint does not accurately quote the transcript. However, she argues that her version of the statement was evidenced by what the defendant actually said. The court's analysis will begin and end with the defendant's first argument. As discussed below, defendant is correct, Meghan Markle, is correct that the allegedly defamatory statement is not in the transcript. More importantly, plaintiff's altered version of the statement differs in substance from anything defendant said. This is fatal to plaintiff's claim because her amended complaint thus fails to plausibly allege that defendant made a false statement. So that statement is yeeted. Because how can you say they said it if they didn't say it? And then the court goes through the case law to get there. Let's go to statement 3. That one, let's go to the final paragraph. The final countdown. Plaintiff's claim is due to be dismissed. However, for the reasons expressed supra, the claim will be denied without prejudice with leave to amend. I don't know if amending that one's going to help. So those two, I don't see the point of reviving them. Statement number 3. Finally, the amended complaint alleges that defendant said, quote, plaintiff only changed her surname to Markle after defendant started dating Prince Harry so that Samantha could cash in on her newfound fame. I don't know, man. Cashing in on fame always seems like a bad idea, especially in the age of social media. It just seems like a bad plan. Like, you live your life, find other ways to make money. Fame is a double-edged sword. It seems from everything we've seen in all the cases that we've covered, it opens up a shit ton of problems that most people don't have to deal with. Defendant argues that the second half of the quote, so that plaintiff could cash in on her newfound fame, is fabricated. She asserts that the remainder of the statement is substantially true and submits state court dockets showing plaintiff used different surnames as late as September 2016. Plaintiff responds to the second half. Well, I mean, it's her maiden name. She's allowed to change her name back to her maiden name. Plaintiff responds that second half of the statement was defamatorily implied. We've gotten to implied defamation. Plaintiff does not specify what about defendant's statement was false, which alone is sufficient grounds for dismissal. Okay. The court's literally like, but where's the lie though? Because it's needed. You have to have the lie. But where's the lie though? The complaint fails to specify what about the alleged defamatory statement is inaccurate or misleading. However, it therefore fails to state a claim for which relief can be granted. The amended complaint merely presents the alleged statement and asserts it was not true. Separately, like the previous statements, this claim is due to be dismissed because it is explicitly contradicted by the transcript that the court is now calling it a reach. Here, the amended complaint did not enclose the entire statement in quotation marks. However, as plaintiff's counsel conceded, it is paraphrased. The court is not thrilled with this complaint. Plaintiff's counsel concedes that it is paraphrased. So the attorneys paraphrased the statement by adding words so that Miss Markle could cash in on her newfound fame. In fact, the interview transcript shows defendant said the following. Oprah Winfrey. So you all weren't close. You didn't grow up together. Defendant, no. Oprah. So, no. Oprah. She doesn't really know you. Defendant, no. She changed her last name back to Markle, and I think she's in her early 50s at that time, only when I started dating Harry. And so I think that says enough. A plaintiff's attempt to plead a viable cause of action may be defeated by her own evidence. The court is not happy. The court is not happy. You've lost it for yourself. The amended complaint accuses defendant of saying plaintiff changed her surname, quote, so that she could cash in on her newfound fame. That's the part I found to be most defamatory too. Again, plaintiff's claim is explicitly contradicted by the transcript. Footnote 9. Oh shit, it's a long one. Oh, the court is mad. Plaintiff's repeated paraphrasing of the record suggests that she may be trying to bring a claim for defamation by implication, which differs from defamation in that it occurs, one, where there is a juxtaposition of a series of facts so as to imply a defamatory connection between them, or two, where a defamatory implication is created by omitting facts. The amended complaint does not allege defamation by implication. The court, if you would like to allege defamation by implication, plead it. If not, don't. But it is two separate causes of action. I imagine that's how they're going to amend their complaint when they refile these, is that they are going to reformat this into a defamation by implication claim, which is probably what should have been done in the first place. Plaintiff's claim is dismissed without prejudice for the reasons expressed. Injurious falsehood. In the second count, plaintiff brings a claim for injurious falsehood. Plaintiff alleges that the same defamatory statements detailed in count 1 harmed her trade, business, reputation, prestige, and goodwill. Specifically, she claims that her mental health counseling business has suffered and her autobiography sales have tanked. Defendant argues that Florida's single action rule bars plaintiff from bringing multiple causes of action based on the same publication and a failed defamation claim. Where is footnote 10? For the reasons expressed, she will be allowed one final opportunity to state a claim upon which relief can be granted. Footnote 10. Although this claim will be dismissed without prejudice, the court has reviewed defendant's argument and taken judicial notice of the court dockets related to the truth of this statement. The court notes that a statement that is substantially true is generally not actionable. The court.
Counsel? Excuse me, counsel. She did change her name. Where is the lie? There needs to be a lie. Counsel, there needs to be a lie. So I'm telling you in a footnote, because I can't tell you directly, that there's nothing you can do to fix this. This one's not going to fly. And that is why this footnote is so long.
The court notes that a statement that is substantially true is generally not actionable. And then it quotes Mason versus New Yorker Mag Inc., explaining that even a flawed assertion of fact is not actionable as long as it is, quote, substantially true, end quote, because the common law of libel overlooks minor inaccuracies. And Smith versus Cuban American National Foundation, holding that falsity only exists if the publication is substantially and materially false, not just if it is technically false. Because if it's technically false and leaves the false impression, then you would need to get to defamation by implication, which they have not done here. The court goes on to say the tort of injurious falsehood protects the economic interests of an injured party against pecuniary loss, in contrast to defamation, which protects the personal reputation of an injured party. Footnote 11. Injurious falsehood is also sometimes referred to as slander of title, disparagement of property, slandered goods. Okay, slandered goods would also be a good band name. Or trade libel. Trade libel is when you're slandering not a person, but like a company. I don't want to give you an example. Make up a company name and let me slander it. Make up a company name and let me slander it. So, if you're going to slander the made up business entity of oral defamation by saying that they sell snake water and that they are, harming puppies or something, then the company can sue for the protection of company reputation, because generally a defamation suit goes to a person's reputation. This gives a company reputation. So the two get treated differently. Does that make sense? Chat, does that make sense? The Court of Injurious Falsehood sounds like a great name for a book. Yes, as long as it goes with like thorns and roses and ruin and all the rest of it. Where's Sarah Mays? We need the court of injurious falsehoods. So the rigor mortis armpit company. They make deodorant that causes cancer because it has formaldehyde in it. So if you say that and it's not true about the made up company, then you can damage the company's business reputation. So you've got to have two, right? So you've got to have two causes of action so that you can deal with business reputation separate from personal reputation. And that's why there are two and sued under two. Single action rule. Under the single action rule, quote, when claims are based on analogous underlying facts and the causes of action are intended to compensate for the same alleged harm, a plaintiff may not proceed on multiple counts for what is essentially the same defamatory publication or event. Not all jurisdictions have this rule. Some jurisdictions allow you to plead multiple theories and allow a jury down the road to pick. It could be lunch meat, could be peaches, whatever. Here, plaintiff's claim for injurious falsehood is based on the same statements as her defamatory claims. Thus, under the single action rule, you got to pick one. The injurious falsehood claim must be dismissed. Footnote 12. This judge has thoughts. Additionally, an injurious falsehood claim requires 1, a falsehood, 2, that has been published. Thus, plaintiff's injurious falsehood claim is subject to dismissal because of the absence of the falsehood and or because defendant did not publish the statements in Finding Freedom. As with the defamation claims based on the CBS interview, the court will allow plaintiff one final opportunity to amend. One more night. Florida courts have disagreed as to whether single action rule applies only when the non-defamation torts are associated with a failed defamation claim, footnote 13. Some Florida decisions contain language suggesting that the single action rule bars non-defamation torts only when they are associated with a failed defamation claim. This is from Ovita versus Bloom. The single publication, single action rule does not permit multiple actions to be maintained when they arise from the same publication upon which a failed defamation claim is based. However, other decisions applying Florida law have rejected non-defamations torts by applying the single action rule, even when the related defamation claims are allowed to proceed. Interesting. Florida's anti-SLAPP statute. Okay. Defendant moves for fees and costs under Florida's anti-SLAPP statute. She argues that plaintiff's lawsuit is meritless and was brought because defendant exercised her right to free speech in connection with a public issue. Plaintiff, her being the public issue. It's like, I'm the public issue. Hi, it's me. I'm the public issue, and this is related to me as the public issue. Plaintiff responds that the statute does not cover defendant's statements and that her lawsuit has merit. The statute prohibits a person from filing a cause of action against another person or entity without merit, and primarily because such person or entity has exercised the constitutional right of free speech in connection with a public issue. That goes into their SLAPP statute. As a threshold matter, neither party argues that the statute does not apply in federal court. Everybody agrees it can apply here. For that reason, the court will follow the numerous decisions from this district that have applied the statute. Defendant seeks to utilize the statute's fee-shifting provision, which entitles a prevailing defendant to an award of attorney's fees and costs. Right. This is the you fuck around and find out provision of the anti-SLAPP. If you bring a meritless claim and you get slapped with an anti-SLAPP motion, you can be required to pay the attorney's fees for the other side having to deal with your bullshit. But it has to be bullshit. If it's a meritful claim, then you don't have to pay the attorney's fees. But if you bring bullshit, you can't just cost people money. We have covered anti-SLAPP quite a lot. SLAPP stands for Strategic Litigation Against Public Participation, SLAPP. You get the extra P's. You get the extra P's. So could Samantha Markle find herself on the hook for Meghan Markle's attorney's fees? Let's see. To claim these entitlements, lawyer's fees. A moving defendant must make two showings. One, that the action is without merit, and two, that it was filed primarily because the defendant exercised a protected right. That right here being free speech. The statute only provides for attorney's fees and costs incurred in connection with the claim. Generally, that's enough, though, because it's fucking expensive to deal with this shit. This shit not referring to this lawsuit, but this shit referring to lawsuits in general. It's expensive. If you get sued wrongly and the other party is just wrong, it is still going to cost you potentially hundreds of thousands of dollars, if not more. I imagine Gwyneth Paltrow spent hundreds and hundreds and hundreds of thousands of dollars, if not more, into the millions to deal with the ski crash case. It's expensive. Which is why these statutes exist, to end the litigation early and to make sure that, you know, if you're bringing a claim like this, you could end up on the hook for attorney's fees. When people have a ton of money, they just don't care. Heather Yokman said, I know I'm late, but I'm related to Alexander Hamilton. I might start singing Hamilton, but I've got to get through the rest of this. Joe Jersey, exactly. Exactly. And Heather, I love that. Thank you. It further appears that fees and costs can only be awarded after a hearing. Here, defendant argues that her alleged defamatory statements qualified as speech on a public issue because they were made in connection with a book and a television program, respectively. She argues that Samantha's suit is without merit for the reasons discussed in the motion. Florida's First District Court of Appeals has underscored the difficulty of ruling on an anti-SLAPP motion in the early stages of the case. We see that proving an action is without merit and filed primarily because the defendant exercised a protected right will naturally be difficult in a motion to dismiss, looking only to the face of the complaint. Because plaintiff may be able to state a claim for defamation after amending her complaint, the court cannot determine that the lawsuit was filed, quote unquote, without merit. Thus, it would be premature to grant defendant's requests at this phase of the litigation. Oh, the court's not ruling it out, though. The court's like, come back to us and let's see. The court will deny without prejudice defendant's request for fees under the statute as it lacks sufficient information. So that's what's coming next. If this is refiled and dismissed again, or if this is not refiled, we are going to probably see this hearing on the anti-SLAPP and attorney's fees. Conclusion: for the foregoing reasons, the court grants the motion to dismiss. Defendant's motion to dismiss for failure to state a claim is granted. Defendant's defamation claims based on finding freedom are dismissed with prejudice. You cannot bring those again. All the other claims based on the CBS interviews are dismissed without prejudice for the foregoing reasons. Plaintiff may file an amended complaint within 14 days of this order. So we should be seeing that soon. This order was from March 30th, 2023. We will see if they refile on this case. It is not an easy case. I don't doubt that all of the attention has damaged Samantha Markle's reputation. Whether that can legally be blamed on Meghan Markle in the context of defamation or defamation by implication is a completely other story. Completely other story. Thank you all for the chat. What do you think of this case? Do you think that this is just like, yes, this may have been damaging to you, but it's time to stop? Like, or do you say refile it? What do you think? Should they refile this case and go the route of defamation by implication? Or do they just need to stop? Or does Samantha Markle need to go after the media that she says has caused the most of this damage? Has the media caused more harm in this than Meghan Markle has? And at that point, does Samantha Markle need to go after the media entities that did this? And with that, y'all, I'm going to watch your answers come in and we're going to fuck around and find out. And then I am going to have to get going for the day because I am sure there is stuff on my calendar that I need to get to. Let me talk to you about scheduling real quick and then we'll get to fuck around. So next week we have a members only live. For those of you that have a member tier that include Zoom calls, I posted updates regarding that. When I sat down and looked at the calendar, I did not even look at the days of the week and see that it was Good Friday on Friday. So I moved that so that we can have that on a non-holiday day that most and many of you, I think, will be spending with family, friends, church, or what have you. So I didn't want you to have to choose between the two. I was like, oh gosh, I shouldn't, that's the wrong date. So we moved that. So next week we'll have our members only live stream. I have a whole bunch of new books. Next week we will start polling for naming the pickle. I just couldn't wrap my head around it this week. I will be offline most of the weekend, spending a quiet and restful weekend with the family. I am just, after 8 weeks of trial, tired. I'm tired. I need a little bit of time. Tomorrow I will drop the podcast episode. If you need the heads up on the podcast episode, it is live on audio today. We love breaking the podcasting charts as an independent podcast. So few are these days. And I am now on iHeartRadio. So if you're on iHeartRadio and you want to give it some love on that platform as well, you can. So the audio only version is up today, talking about the Chrisleys appeal from the criminal conviction. The appeal came in like the same day this did, March 30th. So we were just finishing up with the Paltrow trial, and that appeal came in. With that appeal, it talks a lot about whether that IRS agent gave false testimony and whether the government violated the Chrisleys' constitutional rights by using evidence that was fruit of the poisonous tree. It's a very, very interesting appeal. I am very invested in how this appeal turns out, because there were some real big arguments about what the government did wrong in this case. And the last thing we want is the power of the IRS overreaching into things. The Chrisleys allege that the IRS agent knew that they had paid their taxes and testified to the jury that they hadn't. It's wild stuff. So with all of that, I see some of you asking about the behind the scenes recording. I didn't this week. So we will get back to behind the scenes recordings in the coming weeks. I just recorded so late. I was just like, I have to get through this. So I didn't. I did not. It was it's there for you on your podcasting apps, and I will have the video up for you tomorrow, and we'll get to hang out in the chat at 11 a.m. tomorrow. So that's what we're doing. Dav's Beats said, can you explain the poisonous tree? Yes, I do. In the podcast episode, you're going to have to go listen because otherwise I won't get to questions, because I need to get to questions. And then I have stuff to do here. Frankly, if I don't do laundry, I'm not going to have pants. And my darling husband was putting things in the drink fridge. I love having a drink fridge. I love fizzy water, but was putting things in the drink fridge and dropped a can of Coke that exploded in my laundry room. So that's part of my afternoon is pulling out all of the large machines to clean underneath them, because there is now Coca-Cola underneath my washer and dryer. And so that's going to be part of today. It didn't reach the ceiling. So at least it's contained like 5 feet up on the walls and below. So that's part of our day too. And then the kids don't have school tomorrow. So we're going to, probably catch up on The Mandalorian. If my family can drag me away from binge watching Vanderpump Rules, I'm now in season 7. And I need to do laundry, but I need to clean the laundry room first. So we've got life things that need to happen. Oh, the boys are definitely going to help us move stuff and clean the laundry room. It's going to be glorious, though. We haven't cleaned under the washer and dryer since we moved, so it's fine. So that's what we're doing. Oh, yeah. No, we're cleaning up the soda today. Chat, I also have to tell you, I know that the Markles are polarizing. I know that people don't love the way that Meghan Markle has conducted herself, and people don't love the way the royal family has engaged with Meghan Markle and Prince Harry. There are a lot of like two things can be true at once conversations. Like you can dislike Meghan Markle and dislike the way she was treated, and on and on. Y'all handled a conversation about this case with grace and with dignity, because even if you dislike someone the most, even if someone is the worst, that is where our legal system needs to treat them fairly. All defendants, even the worst of the worst of the worst, have to be treated with the same constitutional fairness as every other defendant. The law should treat everyone the same. And I think in this country, we can always do better, but we have to start with the law treating everyone the same and treating everyone with dignity. And when we have defendants who are unpopular, it can be tempting to be like, yeah, and this is not the case for me with Meghan Markle at all, but it can be tempting to be like, yeah, but fuck them. And I understand that. I feel this way. There are definitely people I feel this way about. It can be real tempting to be like, I don't care if the government's overreaching. Fuck that person. But if we allow that to happen on the people that we think are the worst, it's going to happen on people who we like, people who we don't think are the worst, and people who don't deserve it. So when we talk about the law being blind, the law is supposed to be blind. And I think these cases are a great exercise in both things being true, being able to say, hey, what are my feelings about this person? And how can I take my feelings about this person, how they behaved, what they've done, and look at whether the law is treating them fairly. And it's something that we see in the first year of law school, people really struggling with. You struggle with the morality of like, what happens if you think someone, and this, again, this is separate, really separate from the Meghan Markle case, but what if you think someone is actually super damaging? And you're like, but right, I think they're super damaging. They've done these things, they've said these things, they are a super damaging human. But these cases against them, or these charges against them, or this criminal case against them isn't based on good evidence. It's based on overreaching. Then what? And this is a difficulty in the first year of law school, because your morality and the legality get all conflated. And that is hard to parse. Not many do, Siri. And that's hard to understand. And I appreciate you for being able to walk through that on this case. It's one of the reasons I really like pop culture cases. We're really able to start walking through those difficult differences and being able to talk about how the law should apply to everyone the same. And it should. And a lot comes into that. Money and power and privilege and race, a lot comes into that. But if we're striving for everyone to be treated equally under the law, we just have to continue pushing towards that ideal. And I think that's what makes our system fantastic. But then we also have to know what our own opinions are, what our own thoughts are, and what our own biases are. So we can say, this is how I feel, and I'm going to put it to the side, and this is how I'm going to look at the law. And then we get to do that. Because everyone deserves to be treated with dignity under the law and in this chat. And we do it. And I appreciate you. Y'all are the best. Let's fack around. Y'all, let's just get ourselves to tomorrow. We're going to talk about the Chrisley appeal in the podcast. You can go listen to the audio today. Give it some love. It'll start to chart. I have not watched Schwartzy on Watch What Happens Live, but I'm going to. I've seen I've seen the internet talk about it. And Rita, you said this better than I did. Equality has to include people and opinions we don't like. That is, Rita, you summarized it better than I did. It's very well summarized. Exactly. And that is where we get to dignity, right? And then if people do shit that's wrong, you hold them accountable for the shit that's wrong. So, with all of that, let's take a pickle. Go listen to the podcast on audio. We're going to feck around. I'm going to get to all of our super chats, and then we're going to go for the day. Nothing from you, A-word device. Shush, cancel. All of my devices are done today. Lori, and no one should be. And the law should treat people the same. Let's feck around. We're gonna feck around. We're gonna pickle. We're gonna get ourselves into the Easter weekend. We're gonna take a little time offline, and we're just gonna be like, woosah, woosah.
Also, y'all have sent me some amazing new books. Amazing new books.
So we're going to do that on the Members Only Live. A lot of you have asked about my nails. I went for kind of an Easter eggy vibe. So they're a lot shorter. I can type better though. They're an Easter eggy type of a vibe. That's what I was going for. So that is what's going on with the nails. Let's answer super chats. Does Samantha Markle have pics with Meghan Markle? There are pictures. Some of them were shown in some of the documentaries. So there are some. Emily, I live in California and I'm following it. Fantastic. I will too. Have I ever watched the Chrisleys? Nope. Am I super invested in their case? Absolutely. Thank you for all your case breakdowns. I am too. Look, man, if the IRS can just be like, oh, you didn't pay your taxes, when actually the fuck you did, and say that in court to a jury, I have a lot of concerns. I have a lot of concerns with that. I have a lot of concerns with overreaching. Look, there are plenty of people to prosecute. You shouldn't have to overreach. People do illegal shit all the damn time. But trying to bring in evidence that's been excluded, I don't like it. I don't like it. Look, with integrity, people. Elong said, so can she sue the writers? Here's the problem with suing the writers of the book. You have that malice element. How do you prove that they knew it was false? How do you prove that it was published with reckless disregard? And the comments we're talking about published with reckless disregard are the paths crossed only twice since they grew up, and there's only one picture of them together, and she reached out to the son and they didn't grow up. They barely saw each other. How do you prove that that was recklessly disregarded? The malice element becomes very hard there. Aurelia, good to see you. Question here. Let me move this so I can actually see. So I'm looking here instead of at my side monitor. See, we've got a whole multi-monitor setup. Let me shift this around. Question, didn't Samantha's book come out before the Oprah interview? Yes. Meghan was defending herself against Samantha's claims. Seems so. So how is Samantha's work loss Meghan's fault? It is a very valid point. She is responding and was asked about the book. And then the book sales dropped. And I don't know how the book sales dropping is Meghan's fault. Name for the pickle, Dilly McGurkin. I like Dilly McGurkin. Oral defecation. Oh dear, no, I did. Did I say that? I hope I didn't say that. Katie M, I just wanted to say that I love your hair color. Lots of love from Estonia. Thank you. I overtoned it which I didn't wash out well enough the first time. And my husband's like, your pillowcase looks purple. I'm like, damn it. It washed right out though. Kelly said, my cousin's daughter shares my daughter's name, married the guy, Alex Convery, who wrote the Air movie, Affleck and Damon. It started off as Soul Man. That's very cool. I loved seeing all of your connections to historical figures and royals and celebrity. It was fun. Elena said, watching from Ingleside, Texas. I'm off work today. Yay. So you're going to come run errands with me. Were we productive? We'll stop at Starbucks for a Java chip. Cheers from my, what kind of cold brew did I get today? The caramel cold brew one. Because the pistachio is now gone. The Irish cream is now gone. And they've introduced a cinnamon one that I am not a huge fan of. So caramel cold brew, salted caramel cold brew. Tell me how our Java chip was. Cheers. I'm curious. Jen said, I was watching The Lawyer, with my daughter. And my daughter says, hey, where's Emily? LOL. She is even having withdrawals from EDB. That is the trial downside. Mike Roel said, I'm a university professor, and a colleague of mine about 10 years ago did an adult film, and her students discovered it. Reminds me of the Judge situation. It's so hard because the internet is forever. People can find things, and what you do shouldn't preclude the person that you become, right? So it is. I imagine that would be awkward. Mudslide Life said hello from Dorset, UK. Beer o'clock here. Lovely, and cheers. Diane, there's more good than bad in this world. The media just doesn't cover the good news enough. I am finding, Diane, that I have been able to curate quite a lot of my own intake on social media to find a lot of the good. It takes a bit of work. And it takes some okay, we're not going down this rabbit hole right now, because the news does try to trigger you or inflame your emotions so that you will be like, ah, and then just like click all the way into the rabbit hole. But it can be done, and I am doing that even more. So I am trying to make sure that I'm curating positive spaces on the internet and helping our community to do the same. And it's okay to set boundaries. It's okay to say, not today, fuckery. I'm not doing this. And it's, for me, some of that is making the decision on what to cover and not to cover. A lot of you have asked about the Vallow Daybell case. And here's part of it. And I talked about it Tuesday, and I'm going to keep talking about it and why I'm not covering it. If something legally happens that I can cover without getting too deep into the facts of the case, might I consider that down the road at some point? I don't know. But a lot of our audience wants to be with me for whatever I cover. And I think that case is going to be too difficult to me. And it touches on some very, very difficult and dark shit. I know how that can affect people because I worked there. I've been to autopsies of children. I have done that. And if you don't have to, don't. Because it stays with you. And I don't want to put you in a position where you want to see what's going on with this case, or you want to see what I'm covering, and that this case is not the right case for you. I don't want to cover this case. It is dealing with things that are so, so difficult. There is not much good where I can help explain the criminal process without it being too difficult for me to cover. It is too heavy. There are things in this world that are so dark. If you don't have to know them, don't. There are things I wish I did not know that I will never forget, ever, because trauma is a motherfucker. But I don't want to bring you to that without reason or without purpose. I very, very heavily consider which criminal cases to cover. And I take that responsibility very seriously. So when I chose to cover the Brooks case, I chose to cover the defense because I thought there was room for me to explain what was going on. But we came in after the prosecution did the really hard stuff. And then we're able to cover it. With Murdaugh, I knew there were going to be parts that were difficult, but I also knew because of the court's order that it wouldn't be as graphic as this case will be based on some of the defenses in Vallow Daybell. It is going to be tremendously graphic. They have talked about with the jurors how graphic this case will be. It's a no for me. And I think for most of you, it's probably a no. If you choose to engage, you get to choose how you engage and when you engage, but I'm not going to make you choose my coverage and this case and your own well-being and my own well-being. This case is nope. I know things I wish I didn't. That was my job and I chose it. And sometimes I chose it without fully understanding how it would impact me. And now I understand. And now that I understand better, I can make those decisions more clearly for what's right for me and then for what's right with us. There is no room for lightness in the Vallow Daybell case. Even though I'm sure it's court, there will be moments that are quirky. It's court. But there's not room for lightness in a case that is so fucking dark for me. So when it comes to killing kids, it's generally going to be a no for me because it is so traumatic. And we don't need to know. And I don't want to know. So right now we are going to cover, we're going to catch up on all the things we haven't caught up on. We're going to talk about influencers getting sued over crypto. We're going to talk about, property ownership and goats. We are going to talk about a whole lot of things. But at this point, I am not talking about this case. I know others will. And that's fine. And you get to choose as an audience how you engage with creators that you trust and do that. So the next live coverage I intend to do is going to be Rust. There are a lot of legal questions in Rust, and there is a lot for us to parse there. And there's a lot of legal wrangling that we need to talk about. And we are going to do that all day long. And that's the next thing. And then I have been covering and will continue to cover the college murders case. There is a lot of technology in that case. There is a lot of circumstantial evidence, and there is a lot to discuss in that case. And it's going to be a hard case, but I think that they will be able, especially at preliminary hearing, to talk about it without being as graphic as the Daybell case will need to be. And it's going to be. So that is part of how I parse, and I always want to bring you in. I know a lot of you in the chat are like, you don't have to explain your thought process. I want to explain so that you understand kind of where my, I guess, values or ethics as a creator are, and how I choose what to cover, what not to cover, and why I make those choices. So with that, we will continue on. So thank you for giving me room to explain, and I will always tell you why I won't cover things. There are, indictments of Trump. Am I going to cover it? Nope. Sure not. Sure not going to cover it. Sure don't want to. Haven't even had a chance to read them. Not going to do it. Don't cover politics because we can't have those conversations. Rachel Mills said, will you continue your Britney Spears coverage? Yes, I just haven't had a chance to catch up. And I'm going to be catching up on Britney Spears, Brittany Dawn, the wedding dress case, all the influencers getting sued over crypto. We've got a bunch to get into, and I will. And I'm waiting for the court. I might actually reach out to the court next week. I'm waiting for the court to decide the TikTok case. That is what I want to do. Haley Page, yes. Sarah Boone, New York mom, maybe. The Sarah Boone case is interesting. And there are some defenses that might come up that are legally, I think, going to be really interesting to talk about. So, Jacqueline B said in the chat, yes, thank you so much for not covering politics. It brings a lot of toxicity, unfortunately, and it goes against what we do here. What we do is we have compassionate conversation, and in politics on the internet, there is not a lot of room for those conversations that you might be able to have in person, but sometimes we can't even have those conversations in person right now. And while I understand why, it's not what we do, but also I realize that there's a lot of views to be had on those types of things, but that's not our audience. And I'm just really happy with how much we learn through the cases that we choose. And there's plenty of room to go find that on the internet. There's plenty of room to go find it. I think it's really nice to find a place where you know what you're getting and you're not going to accidentally stumble into a conversation that you did not choose. Sarah Walker said, question, but not a question. Kori's next dream is to see his mom's channel. Get a silver button for her channel, The Crap Goth. Hit her channel as well, please. We did, Sarah, and thank you again. I just brought that up to remind everybody. Those links are in the description. EDB, you live streaming on my birthday is the best present. Marissa, happy birthday. Yay. Jennifer said, a pirate I have been following and has touched my whole family. His biggest wish has been to have his mom's page get a button. Lawnards, we can do that. Yes, we can. And that is linked down below. Better with the Irish as someone who is sitting here doing 6 hours of IVs every other day. I love how they share the journey with positivity. It's hard and they are so gracious. It's inspiring, isn't it? It really, really is inspiring. H2 Sweet, can we get a nail check? We'll do one more. Yes, we always can. Yes, we always can. Simply Cheryl, a great reminder. Those are links in the description. Emily, what an important reminder. Compassion, joy, and love is everything. It really is. Look, our days on this earth are the days that we get. But if we're not spending them with a bit of fun, it can make it real hard. Yeah, we're going to get back to Bad Spaniels, Jack Daniels. I have that on the list for next week. Can we add Judge Newman's Bring the Jury to the Soundboard? Yes, when I remember. You're awfully nosy. I am, Paula. I have made no small bones about this. I want to know people's life story. I'm fascinated by people and the lives that they live. I have some interviews coming up that I think you guys will be, that will enjoy. I'm going to bring some people on to interview for the podcast that I think you will like. But I want to know people's stories. It's one of the reasons enjoy these court cases. You see people's stories through what they're going through in these cases. Did somebody send Judge Newman to bring the jury mug? I will send Judge Newman one. Judges generally can't accept gifts, but we'll send one anyway. Just me. Court cue. Judge in the staunch trial asked the jury if they have questions for a witness after redirects. Common. Depends on jurisdiction. I think it's very helpful to the lawyers, but it can be difficult to navigate if the jury asks questions that can't be answered under the rules of evidence. So judges have to be very good at dealing with it. Do we know if Cousin Eddie has a deal to testify or is he not cooperating? We heard in that hearing that Cousin Eddie is cooperating. Jennifer said, I just subscribed today. Welcome. Can you please give a shout out to my friend Lakia? Thank you for giving that to me phonetically. I appreciate it. I'm the worst. Shout out to my friend Lakia who told me about your channel. Well, thank you, friend Lakia, and I'm glad you are both here. Jennifer, Nikki Crayons in the chat. You are hilarious. Hello. My coworker just walked in and said, is that EDB? I love her. Hello to Nikki and to your coworker. I love you both as well. It's always fun when you find out that a friend is a law nerd. Emily, what's your Starbucks order? Right now, it's the caramel salted caramel cold foam cold brew. I kind of miss the pistachio one. I very much miss the Irish cream one. I love the pumpkin spice one. I love it. You can't tell me otherwise. My friend Viper is like, ugh, pumpkin spice. And I'm like, my basic ass needs a PSL. Have worked in institutions. If he is gaining weight during initial incarceration, he is adjusting well. KDB also might be health stuff. I don't know if this is Cousin Eddie's first incarceration. So yes, it might be initial on this case, but I don't believe it is his first rodeo. I got my Law Nerds Love zip hoodie yesterday on my birthday. It's so fantastic. Best hoodie ever. Roro, aren't they comfortable? Aren't they comfortable? This guy was taken advantage of by Alec Murdaugh. I truly doubt he had anything to do with the suicide attempt. Oh, Cousin Eddie was involved. Murdaugh asked him to. I don't think it was his idea, but he said that he was involved. Emily, do you live by a Starbucks? Not close enough. They are far away from me. They are far away from me. But today I had stuff that I was out and about. So if I'm passing a Starbucks, we will do it. Question, I'm not from the US. How do bonds work exactly? I don't know if I'm the best person to answer this. But generally you put up collateral and the bond company makes sure that you come to court by either keeping your collateral or taking it. And then they put up the bond with the court for an amount of money. That's a very, very simplified version. Tracy, we talked about Cousin Eddie's medical treatment. So we got into that. I agree. More Judge Newman in all aspects of life. Crushing on Judge Newman. Thank you, Emily. You rock. I like Judge Newman's judicial temperament so much. Chris B. Hey, Emily, I'm currently flying through your coverage of the Alex Murdaugh trial. I can't stop watching. Just popping in to say hello. Well, I'm glad you enjoyed it. And I'm glad you get to watch it sped up a little bit. Emily, have you ever witnessed lawyers being rude to the judge and their responses? Yes. Oh, yes. Oh, yes. Lawyers are often ruder to each other, but yes, I've seen lots of lawyers be rude to judges. Allison said, EDB, you and your chat always makes my day. Our chat makes my day too. It's been tough lately, so I'm happy to be with y'all live this morning. I'm glad you're here too. KDB said, in Texas prisons, each unit has a clinic and all conditions are treated and medications are provided. If more medical care is needed, we have a regional hospital care, which is how it should be. It just doesn't always work like that depending on the jurisdiction. Thank you for keeping chat in discussion. Always. Chat is the best. Chat is the reason I live stream. Chat is part of why I'm here and part of why I stream for hours and hours, because I love chatting with chat, because chat is bae. Elisa, being a law nerd, can have additional helpful discussions on a day-to-day basis when dealing with the public and to have better conversations. Hopefully. I think so. I love that we're just kind of elevating the way we have conversations and talking about it. I think we need to get back to being able to have conversation. And if we can start here, then that's fantastic. Fiji said, is the case yeeted? Part of it is permanently yeeted. The other parts are also yeeted, but they can refile. Do they not have to use Meghan's legal name? I don't know. Is Meghan Markle not Meghan Markle's legal name? Is it like Raquel and Rachel? I don't know. I'm just in the season where Raquel Rachel pops into Vanderpump Rules. So that's where I'm at. You're welcome. Thank you. Anifa said, Emily, I was wearing my I Love Cursey Words hoodie when a red wasp, oh God, landed in my hood. I cursey worded it off immediately. Pointer Sisters in full public performance before I made it inside. Those wasps are the worst. They are the worst. I'm sorry, and I hope you are well. That is terrifying. Super Susan says, my kids are 10 years apart. I always say it was like raising two only children. Their activities and interests way different. Thanks for all you do. You're welcome. It is, I mean, even my kids are 4 years apart, and having one in elementary school and one in high school is a vast, vast difference. And they get along most of the time. I mean, as brothers do, but it's a vast difference. There has to be malice, and there isn't any. The chaplain, that is a great point. The chat can talk about red wasps. These are region specific. Emily, watching your videos helped me cope during bad work days. I'm here for you. Been rewatching past lives with missing videos, and will you re-upload them in the future? Missing videos. I don't know what missing videos. So let me know if you're not seeing something, but most of the lives they shouldn't be missing videos. But I can always go look. Some of my older stuff from when my channel was tech and stuff is down because I don't want the algorithm being like, come watch this video about a new iPhone. And then they get here and they're like, what the fuck does this channel do? Lynn says there is a 18 and 6-year difference between my oldest two and my youngest. The older two don't live close like Megan's siblings did. I call BS. Kelly said, my sister is almost 12 years younger. We grew up like two only children. We're not as close as if we were only a few years apart, right? Because your lives are completely different with those age differences. It's just a difference. Samantha Markle gave docs proving she used Markle way before Prince Harry, which again is fair, but I don't know if it's a lie that she used to go by a different name and changed her name. But then again, it's not a nefarious thing. If you're married and get divorced, that you go back to your maiden name. That's not nefarious. Kimberly said the institution was not killing stories in order to help the members of the family closer to the crown. So she thought if they killed the story, it was true. The institution may never help them again. Okay. So it was asking for the help was the issue. Kimberly, thank you for that. I appreciate it. Joe Jersey, no teachers who have been late to class. I love the name. Also a great band. That's funny. Late to Class is a great band name. I live in Lakeland, Florida, and I didn't know she left here or lived here. I think many of us don't know she's here. There we go. Smudge the pickle. I mean, it really kind of does work in that way. Mr. Rogers was at my mom's wedding. Electric squirrel. That is the coolest shit ever. Did she say, won't you be my neighbor? That is so cool. I love that. I love that. Try the Starbucks inside of Targets. They still have them well after the season is over. I will. Those don't have the drive-through, so on rainy days. Elena said, we were very productive and the Java chip was good. Elena, go us. Way to co-work it today. I have to answer some emails today. I have financial things I have to do. I avoid it so badly. And then when I get done, I'm like, oh, that wasn't so bad. Every single time. It's one of those things. Shauna said, tip, buy some Torani Irish cream syrup, get a plain cold brew with sweet cream, add the syrup. It tastes the same or better. That's a great idea. I didn't know that Torani made Irish cream syrup. I love their syrups and I will look for it. Abby said, my master's research was sponsored by a 3-letter agency involving child abduction, homicide scenarios with forensics. Oh, Abby, it was dark. I wanted to do a PhD, but was said too dark, however needed, been cited 4 times. That's a lot of work. Take very good care of yourself. The Fuji trial, pretty please. I have not delved into all the context of that, so I don't know. There's a lot there. So we will think. Music to My Soul said, Monday was my birthday. I might reward myself with ordering some of your merch. Thanks for being my favorite unofficial coworker. I am here to be all of your unofficial coworkers. Chat is Bay merch. I will put it on the list and consider it. with all of that, all of y'all are talking about your taxes. Yeah, I've got a bunch of stuff to do. Agatha Rose, I'm behind. Is EDB SJM? What is Samantha J. Is that Samantha J. Markle? I don't think I'm a fan of anybody in that lawsuit. It's an interesting lawsuit, but I have no real feelings one way or the other with anybody. I think I think you mean Samantha Markle. It's a weird suit, and I feel bad when people get pulled into the public eye or their family do, and the public or the internet more likely goes wild and destroys their lives. But it's a hard thing to navigate with law. I'm really interested in how to deal with that. Like, how do you deal with internet and cyberbullying? Not necessarily how do you deal with Sarah J. Mays. Yes, that I am a fan of. I was like, are we talking about Samantha Markle? Yes, no, yes. Yes. My brain doesn't always connect the dots appropriately. Amber Mospan, congratulations on your sobriety. But to get back to what Lindsay was, I'm not done yet with what I was talking about. So I'm very interested in how people are going to navigate cyberbullying, because cyberbullying is a huge issue, and where we get boundaries on the internet, because the harm is very real. But is it defamation when their opinions and their name calling and their harassing, and do the online harassment laws encompass cyberbullying well enough? Like, where does this stuff fit, and how we navigate this is something I'm very interested in following. And then what do we do with deep fakes, and what do we do with, streamers and I've seen this more with streamers. I'm sure it happens with all kinds of celebrity, but when you deal with, people in the public eye being turned into things they didn't consent to, into adult content that they didn't consent to, and have their voices used for things they didn't consent to, where are the boundaries? This is where my brain is at. Like, how are we dealing with these things? So when I'm looking at like what lawyers are doing and what bar associations are doing, I'm like, how are we navigating the harm that could be here vis-a-vis rights to free speech and rights to have opinions? Like, where are the boundaries? I'm fascinated by those types of boundaries. Lindsay said, I was out with friends for my birthday lunch yesterday, and a new mom friend eagerly asked, so how is EDB? Thanks for giving us another connection. Let me tell you how EDB is real quick, and then I'm going to go. So for those of you that are left, here's the story. Don't tell anyone this is hiding at the end of this stream, because we're all friends on the internet. And this embarrassed me, but also we were at the fall meeting for the band parents. Love band parents, love band, love the fall, love the adults that work with the band at my kids' school, love everything about it. And one of the adults and my husband had been talking about a medical professional, and my husband needed the name of said medical professional. We've had these types of stories before, but my husband needed the name of the medical professional, and the name of the medical professional is Licky, like the Pokemon. And so what immediately came flying out of my mouth to not another parent, but one of the adults that works with my child in the band was, well, I'm so glad they're not an OBGYN. I guess I could have also said podiatrist, proctologist. Like, there's a lot of directions that could have gone flying from my mouth. So for Dr. Licky, I apologize. But also, I am glad that you are in a field that does not lead to the inappropriate jokes. And now people understand why I do not have a real job, because the shit that sometimes just comes out of my mouth is just... And I'm like, oh my God, I'm so sorry. I'm not with the law nerds right now. So these are just... There was a lot of laughter though, so I feel like it was received in the way that it was supposed to happen. But I just so to Dr. Licky, not an OBGYN, not a podiatrist, not a proctologist, not a dentist. I thank you for the humor, and I appreciate you for not changing your name. Like, just Just get it. Though where I used to live, there was a Dr. Naylor who was in the high risk OB field. And so the Nailer, I don't even know her, was one of those things that you could never get away from. I'm like, oh, Dr. Naylor. It just is. But also my brain. You know the direction the brain goes in. I couldn't get through any of the Distinguished Johnson parts of the case today. So when Travis, yes, it just is. It just is. So with all of that, sometimes the real world also is just like, Laura Gray said I had 2 dentists with the last name of Beaver. Again, at least Dr. Beaver is not an OB. So this is what you have to consider with. If you're going to med school, you have to consider your last name. Stina G said, my first prego appointment with husband there, doctor gets the speculum, hub starts duck calling. Doctor still makes duck calls at every appointment. It's been 13 years. I love that so much. I love that so much. That's fantastic because we're human. Look, we're just human. There's got to be some room for it to be funny. So the pickle is now known as Dr. Licky. Oh, that might have to happen. That might have to happen. AD Bazaman, I think I did that terribly. Present to myself for my 76th birthday last week. I have question tea arrived last night. Neighbor says it's totally me. I love it. Happy birthday. Happy birthday. Ann Bell said, success. I convinced hubby to get me a zip up as I have questions hoodie. It applies to my work as well. Perfect. So Lindsay, long story short, you are welcome. Beats Kill Bean said my first OB was named Dr. Beaver. Maybe some last names you just have to lean in, right? Just have to lean in. So with all of that, chat, you are bae. I appreciate you. Mods, thank you for riding for a little bit longer than normal stream. I'm going to go do the things I need to do for the rest of the afternoon, and I will see you soon. I'll keep you posted around social media on how cleaning up my my laundry room goes. And what else? And then in the Law Nerd Alert on Monday, I will give you the whole layout for next week. And have a wonderful Easter if you are celebrating. And if not, have a wonderful weekend with some downtime, hopefully for yourself. All right, Law Nerds, I will see you next week. Bye.
You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at the Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.